All right, we are back on the record, ready to continue this morning. Our alternate, Mr. Cook, has been substituted for Mr. Hall, who has been excused by the court. So we're prepared to continue. So we're at the cross-examination of Officer McLeod. So Mr. Hinton, you may begin your examination.
Thank you, Your Honor. Good morning.
Good morning, sir.
You indicated that you were patrolling on January 31st, 2025, which was a Friday at approximately 11 o'clock p.m. Is that correct?
Yes, sir.
And that's when you noticed an individual in a vehicle wearing what you describe as a mask, correct?
Correct.
And you had also indicated that you thought that that person was slouching over, right?
Correct.
Okay. And my question for you is, if the person was slouching over, how did you see their face?
I'm sorry?
If the person was slouching over, how did you see their face?
Because they were sitting more upright in the chair, or I should say in the seat, prior to seeing me. Once they began passing me is when I observed them slouch back in the seat.
Now, you did have a chance at some point to get a closer look at the individual, correct?
Correct, when I made the traffic stop.
And that was Mr. Robinson?
Correct.
Okay. And the mask he was wearing wasn't a full mask with holes for the eyes or anything like that, right?
Correct.
Okay. It was just something that was covering the lower part of his face?
Correct, up to his nose.
Okay. Something that would be used for warmth?
Yes.
And this wasn't a situation where you received a call or you were dispatched out to a suspicious individual wearing a mask, correct?
Correct.
Okay. You just happened to notice this car drive by, right?
Yes.
Okay. And you end up getting behind the vehicle, correct?
Yes, sir.
And the reason that you effectuated the traffic stop was that the tail light was emitting some white light, right?
Correct. When the brakes were applied, it was emitting a white, bright light.
And there was some sort of small crack in the tail light?
No, the top portion of the actual red reflective cover was missing.
But the reason that you stopped the vehicle was the equipment violation, right?
Correct.
Now, was it a slower Friday night for you?
I don't recall.
There just wasn't much going on other than cracked tail lights?
Yeah, I don't recall our call volume that night, I'm sorry.
Now, when you stopped the vehicle, you got out pretty quickly, correct?
Correct.
Okay. And you did not see any sudden movement or anything like that, right?
Not that I was able to observe.
And you went over to the driver's side of the vehicle?
Yes, sir.
And almost immediately after you approached the vehicle, Stacy Reichert had indicated that there were two guns in the vehicle, correct?
Correct.
And when you were testifying yesterday, you had mentioned a change in the law called the constitutional carry. Do you recall that?
Yes, sir.
And what did the constitutional carry change in the law?
It allows qualified adults that aren't under disability to carry a loaded firearm without a CCW permit.
So prior to that law change, the only folks that could carry a gun in a vehicle would have to have a CCW or otherwise be permitted to do so, correct?
You're saying prior to the law?
Correct.
Correct.
Prior to that change. And under the prior law, before the constitutional carry, there was a duty that the occupant of the vehicle, if they were carrying using their CCW, that they'd have to disclose to an officer that there was a gun or a weapon in the vehicle that they were carrying, right?
Correct.
Okay. And under the new law, the constitutional carry, that's not a requirement anymore, right?
Unless asked by the officer, they are
Correct.
required to disclose it, yes.
Correct. And you said that's why generally when you approach a vehicle under this new law, you ask right away.
Absolutely.
Right? But if you didn't ask, a person that you stopped wouldn't have an obligation legally to tell you that initially, right?
Correct.
Okay. But in this situation, despite the change in law, Ms. Riker did immediately inform you that there were 2 guns in the vehicle, right?
After I asked, yes.
And as far as and I'm calling it the new law, it's been in effect for a little while, but as far as the constitutional carry law, that law does permit folks to have a loaded firearm in a vehicle while traveling, right?
Correct.
Okay. So when Ms. Reichardt was testifying yesterday about thinking that guns had to be unloaded in a vehicle, that wasn't correct, right?
I'm sorry, could you repeat that?
When Ms. Reichardt testified yesterday that she thought to transport the firearms in a vehicle, that she'd have to have them unloaded, that's not what the law actually states now, correct?
Correct.
And she mentioned that she had taken a CCW class years ago.
Yes, sir.
And when you approach a vehicle and were notified that there were firearms in the vehicle, you did in fact observe 2 firearms, correct?
Yes, sir.
And those were both closer to Stacy than they were Mr. Rock.
They were touching Stacy's left thigh, correct.
Okay. And they were situated in a way where you could see that the magazines were out or that they were otherwise unloaded, correct?
Correct.
Now you had indicated that you thought that was an odd way to have the firearms position, right?
Yes.
Okay. And it was odd to you because it's not a requirement that these be unloaded or on display or anything else, correct?
Correct.
May I approach, Your Honor?
You may.
I'm going to hand you what's been marked as Exhibit 3A.
Thank you, sir.
Sir, do you recognize that document?
Yes, sir.
And that's a picture of the firearms that you took after the fact, correct?
Yes, this is a photo I took at our station in our temporary evidence room, both firearms prior to them being secured in the package, correct.
Now, where's the picture of the firearms in the vehicle before they were moved?
There was not one taken.
Okay. So you didn't take a picture to show their exact location in the vehicle?
No.
Now, after you approach a vehicle or inform that there's weapons, see the weapons, you have Stacy remove herself from the vehicle or get out of the vehicle, correct?
Yes, sir.
Okay. And there was another officer that had responded soon thereafter?
Yes.
That was Officer Witt?
Correct, sir.
Okay. And had you called ahead to Officer Witt as you were making this equipment violation stop?
As
for backup, or what, how was Officer Witt there so quickly?
so our standard procedure on night shift, once it gets dark, we have 2 officers on every shift, every traffic stop and every call. It's our standard procedure.
No matter what it is?
No matter what it is. Doesn't matter if it's a noise complaint, traffic stop, barking dog. We send 2 officers to it once it's dark outside.
And when Stacy got out of the vehicle, Mr. Robinson, or Lorenzo, how I'll refer to him as, stayed in the vehicle, correct?
For a moment, yes.
Okay. So by your command, Stacy left the vehicle, left the guns in the vehicle, and Lorenzo was in the vehicle with the 2 firearms, correct?
Correct.
Okay. And then you had Lorenzo get out of the vehicle, right?
Correct.
And you had indicated that at some point soon thereafter you began having a conversation with Stacy, right?
Yes, sir.
And you indicated that you thought she seemed nervous, right?
Yes.
Okay. But you had let her know that because there wasn't a licensed driver, either her or Lorenzo, her car was going to be impounded, right?
During the stop, yes.
Okay. And she was actually cited for allowing Lorenzo to drive her car without a license, correct?
Yes, sir.
Okay. So the fact that she was nervous could have been the fact that her car was being impounded and she was being cited, right?
Possibly.
And you indicated that she was continuing to look over in Lorenzo's direction when you were speaking to her?
Yes.
Okay. And it's possible that she was looking over to see if he was being arrested or seeing what he's doing, correct?
Possibly.
Now, you had indicated that there was marijuana near the firearms as well, correct?
Correct.
Okay. And at this point in time, January of 2025, marijuana was legal, correct?
Yes, sir.
Now, at some point after your speaking with Stacy, you bring her behind one of the cruisers, and Lorenzo goes inside a different cruiser, correct?
She was seated inside Officer Prugel's cruiser while Lorenzo was placed in my cruiser, correct?
And that's right around the time that you asked her if Lorenzo's DNA was going to be on one of the firearms, correct?
Yes.
And your line of questioning with her is first you asked if the guns were hers, correct?
Yes.
And then you had asked about if one of the guns was going to have Lorenzo's DNA on it, correct?
Yes.
You asked a little bit about the positioning of the guns, right?
Yes.
Okay. And you had some conversation with her as to whether or not the guns were loaded, right?
Yes.
Because the observations you made is that the guns were not loaded, right?
Correct.
And when Stacy stood up and was taken out of the vehicle, along with the two firearms on her seat was one of the magazines, correct?
Correct.
And the other magazine was located in her purse, correct?
Correct.
Okay. And then there was a single bullet that was located on Stacy's side of the vehicle by where her feet would have been, correct?
Yes.
And you had, again, asked Stacy if she owned both of the guns, right?
Yes.
And did you do any independent verification to determine whether or not she owned the guns? Were you able to call in the serial numbers or anything like that?
So we are able to run the serial numbers through our central dispatch. I ran both the serial numbers and neither one came back on file. Normally when they are going to get a hit, they're normally for a stolen firearm or something in that nature.
So these firearms both had their serial numbers on them, right?
Yes, sir.
And these firearms didn't come back as stolen?
Correct.
Okay. And you had no reason to doubt Stacy and that she owned both of these firearms, right?
No.
Now you had indicated to Officer Prugel that both of the firearms were under Stacy's butt or behind, correct?
That said that they were next to her left thigh.
Okay. And you had let Stacy know that you were going to talk to a supervisor, right?
Correct.
So this was a little bit of a different situation when you have two folks in a vehicle. One person's allowed to have firearms, one person's not, and the person that has the firearms is the owner of the firearms, correct?
Correct.
And the guns are located, basically on or touching that person, correct?
Correct.
And you weren't exactly sure how to handle it because it was a different type of situation, right?
I wanted to run it by my supervisor, yes.
Certainly. Now, after speaking with Stacy about the firearms, you did ask her questions about other items in the vehicle, right? Did you ask her what was in the cup in the center console?
I don't recall.
Did you ask her about the scale that was located under the seat?
I don't recall if I talked to her about that or not.
And the reason you may not recall some of these things is because this took place January 31st of 2025, right?
Yes.
And you've probably conducted hundreds of traffic stops since that date, correct?
Correct.
And did you do anything to prepare yourself or refresh yourself for purposes of the trial this week?
Yes, I read my report and watched my dash cam.
And that dash cam, it is a bit choppy as far as the audio, correct?
I wouldn't say necessarily, but
And is there multiple people kind of talking at the same time during the dash cam?
yes,
Is it a little hard to hear everything that was said?
a little.
Because some of the conversations weren't necessarily taking place right in front of the vehicle where the dash cam was facing, right?
So just because it's in front of the vehicle doesn't mean it's going to catch. There's a mic inside the vehicle and there's a mic that we wear on our body that catches all the audio.
And with that in mind, did you have any body cam that was recording anything during this encounter?
Our department does not issue body cams.
Now, you had indicated yesterday that you thought you spoke with Stacy for 20 or so minutes.
I said on and off for about 15 or 20 minutes.
I mean, if I told you I went through the video and it seemed closer to 10 minutes, would that surprise you?
Not really.
And again, I mean, you're making an estimate based on something that happened several months ago, correct?
Correct.
Now, again, during this off and on, 10 minutes or so conversation, you're trying to investigate, right?
Correct.
And you're asking questions. Hey, is Lorenzo's DNA going to be on one of these guns? Things of that nature, correct?
Correct.
And you acknowledge that Stacy was nervous and in the process of having her car impounded, being arrested, etc., right?
Correct.
Okay. Now, you didn't have her do a written statement, right?
No.
And you didn't follow up with her the next day and say, hey, I know there was a lot going on last night. I mean, why don't we sit down and talk again about this situation, right?
I had went to speak with her at the request of my supervisor that same night.
But what about the next day?
No.
And you really didn't do any additional follow-up as far as speaking with her, right?
No.
And you hadn't asked her if there were any other occupants in the vehicle at all?
No.
And you hadn't asked her, where they were coming from?
I had.
And did you have her come into the station at all and sit down with you?
No.
May I approach you?
You may.
I'm going to hand you what's been marked as State's Exhibit 3D.
Thank you, sir.
Do you recognize that
Yes, sir.
document or picture, and what is it?
This is a photo I took of the 10 millimeter magazine in our department's temporary evidence room.
If I may approach
You
you,
may.
Your Honor. I'm going to hand you what's been marked as Exhibit 10C. Can you recognize that?
Yes, sir.
And what is that?
This is a photo I took also in our temporary evidence room of the digital scale that was located in the vehicle.
Now, there was a form that you testified to about yesterday. It's okay if I keep approaching?
Yes, you
Your
may.
Honor?
Yep.
Thank you. And that was State's Exhibit 6. Do you recognize that document?
Yes, I do.
Okay. And that is a submission form that goes over to the crime lab, is that correct?
Yes, sir.
And on that form, there's an indication of what is tested for DNA, what's being tested for analysis, what's being tested for fingerprinting, right?
Correct.
And who fills out that form and makes those determinations?
So I initially fill out the form, however, it's then reviewed by our evidence supervisors that take the items to the crime lab.
And referring back to exhibits 3D and 10C, the magazine and the scale, both of these items have shiny silver surfaces, correct?
Correct.
Yet the submission form that you testified about yesterday doesn't have fingerprinting being done on the scale, correct?
Correct.
And there's not DNA testing being requested on the scale either, correct?
Correct.
You're not the officer who located the scale in the vehicle, correct?
Correct.
And you're not the officer who spoke with Mr. Robinson about the scale, correct?
Correct.
You had indicated yesterday that when you were speaking with Stacy that her voice was crackling a bit.
Correct.
Wasn't that happening when she was testifying yesterday?
A little.
I mean, isn't that kind of how she talks for the most part?
I've talked with Stacy numerous times over the years, and no.
I mean, doesn't she seem like a nervous person to you?
Not normally, no. When I've spoken with her.
I have no further questions for you at this point. Thank you.
Thank you, sir.
Redirect examination.
Thank you, Your Honor. Officer McLeod, if an individual claims ownership of something like a scale, are you going to ask for prints and DNA?
No.
And so in this particular case, when the defendant claimed ownership of the scale and said that it was his, were you going to have it sent with prints or DNA?
No.
Well, let's talk about in your conversations with Stacy on that evening and the way that she appeared in court. When you were speaking with Stacy in the back of Officer Krugel's car, did her demeanor change from initially when she was talking to you?
Yes.
Okay, tell me how that changed.
It's when I was talking with her outside of the vehicle, again, she continuously kept looking over at Mr. Robinson, appeared very nervous, the voice cracking. Once that she was placed in the rear of the vehicle and I was speaking with her, she appeared to calm down, her speech started to slow, she began to open up more, become more clear with her discussion with me.
Okay, so the way that she was talking yesterday when I was questioning her in front of Mr. Robinson, that's consistent with the way she was talking to you initially in front of Mr. Robinson.
Very consistent.
Objection.
Sustained as to the way of phrasing the question.
When she was testifying yesterday and Mr. Robinson was in the courtroom, how would you compare her voice yesterday with that to the time you were talking to her in front of Mr. Robinson at the scene?
It was very consistent.
Mr. Hinton was asking you a question if you had asked where they were coming from and you didn't get a chance to answer that. So if you could explain for us, what did you talk to them about where they were coming from?
I asked them where they were coming from, and Ms. Riker had advised me that they were coming from her work in Madison.
And Mr. Hinton asked you some questions about why didn't you follow up with her the next day? If somebody on scene tells you what happened and you have a clear understanding of what happened, and they tell you that and they tell another officer that as well, did you feel it necessary then to follow up the next day?
No.
Did you have any confusion about what had happened?
No.
And when you said that you had spoken to Stacy on and off for about 15 to 20 minutes, Officer Flugel also had an opportunity to speak with her. Is that a fair statement?
Correct.
And you were on scene for quite a long period of time.
Yes.
And you don't have, there's no body cameras issued by your department, is what you said, right?
Correct. Just our dash cam.
Okay. Now with the dash cam, during the dash cam that you were reviewing, there was a lot of conversation between you and all the other officers throughout this entire time, right?
Yes.
And so if you're going to listen to that, it's a lot of conversation between the officers and not necessarily conversations with other people, but you can hear all kinds of background noise, you can hear the traffic, it's very difficult to discern a lot of it. Is that a fair statement?
Fair.
And in terms of stopping the vehicle and what the defendant was wearing, there's no doubt that it was pulled out.
Oh, yes.
But you indicated that the reason that you thought it was odd was because of why?
Because he's driving around with the windows up.
And was he also wearing anything else other than that mask?
He's wearing a black hooded sweatshirt.
And do you know if that was up or down?
It was up.
So the hood's up, and he also has the mask on. And normally, seeing somebody in the cold, that wouldn't be an issue, right?
Normally, no.
So why was it odd here? What drew your attention to it?
Again, driving a vehicle in a high crime area that late at night, then the slouch back in the seat to try to avoid what I ascertained is trying to avoid my line of sight. It all painted a picture that he was trying to avoid contact for some reason.
And is that based on your training and your experience and your work with the police department?
Yes, ma'am.
Now, Mr. Hinton said that his term was slouching over. Can you explain what you mean? Because when you demonstrated it, it seemed different to me. If you could explain.
Yeah, so he's sitting more up. I say he as a result of the investigation. I should say they. So when they were passing me, they were sitting more upright. Upon passing, it was a slouch back in the seat.
Okay, for purposes of the record, you're moving your body down and backwards.
And backwards, correct, is what I observed.
When you observed that, did you immediately pull the vehicle over?
No.
What did you do?
I conducted a further investigation. I ran the registration through LEADS, again, Law Enforcement Automated Data System, to see who the vehicle returned to. I got behind the vehicle, waited to see if I could develop probable cause to stop the vehicle, which I did with the broken tail light.
And in this particular case, you spoke to your supervisor. Is that unusual to speak to your supervisor during any kind of a traffic stop?
No.
So this is not like an anomaly here. This is something that you would routinely do.
Correct.
Did you have any question after speaking to Stacy Reichert after observing what you did in the vehicle as to what had occurred?
No.
And here, there's a question asked of you about photos on scene and why there weren't photos on scene. When you were on scene and you had Ms. Reichert get out of the vehicle, what did you tell the defendant to do?
Place his hands on the steering wheel.
And where was he in relation to where you were?
So I was at the driver door. He was sitting in the vehicle just on the other side of the driver door, maybe not even a foot away from me.
And at that point in time, were you going to take photos?
No.
And then what did you have to do?
So at that point, for everyone's safety, for officer safety, I needed to make sure both those individuals were away from those firearms, again, for our safety, so that we could discuss what was going on and conduct our investigation as needed.
Okay, and did those firearms need to be immediately secured?
No.
Okay. And so when you were on scene, and this is occurring, and you then go back, you have both individuals out of the car, what do you do?
So I go and I speak with Ms. Reichert while Officer Witt spoke with Mr. Robinson at the rear of my patrol car.
And there are two other officers on scene and they're up in the vehicle.
Yes, near the vehicle, yes.
So at that point in time, everybody has an obligation, things that they have to do at that point in time.
Correct.
Was it feasible to take the photos at that point in time, or was it something that you had to do back at the station?
It's something normally we do at the station.
Now, there was a question about, that Mr. Hinton asked you again, about the way that these were situated and how close they were to her leg as opposed to him. And I think, and I know yesterday we did a demonstration, and the chair that I used had arms on it. Did the chair, or the seats in this vehicle, did they have arms on it like that?
No.
Okay. So, so when I'm looking at this chair with the arms on it that I'm wheeling here, it's not like this, right? Not like, this is not how the seats look.
Correct.
Okay, so when I look at the arms of the chair that are here, were those present in the chair, in the seats in the vehicle?
No.
Okay. Forgive me for a second, but. If I show you this yellow chair, is this more consistent with the type of seats that you're looking at in that vehicle?
Correct.
Okay. And so if we have the passenger seat there. Sorry, Sam, you run around. Okay, so if I have these two yellow chairs next to one another, in terms of the size of these chairs, is that fairly consistent with what they look like there?
Yes.
Smaller, larger?
Consistent.
Okay. So in terms of this, in terms of sitting in the chair, if I'm sitting in the passenger side of the vehicle, is this about the same proximity that she would have been to, and if you need stuff, to where the defendant was?
So to account for the small depressed center console.
Keep your voice up, please, since your back is to
I'm
the...
sorry. To just account for the small depressed center console, that would have been right about here. That would have been about the distance,
Okay, so
approximately.
how much of the distance is it here, just for the record?
Less than a foot.
Okay, all right. Let me stay there for a second.
Why don't you step by the red folder there so that you're facing the jury, talking to Officer McLeod.
And so, we were talking yesterday about the proximity of everything, why you thought that it was odd. The two firearms, if I'm Stacy, can you show me how they work? 'Cause I know we had, it was hard to see with the way that the
Yes.
part of that chair was. So I can switch over a little
Yeah.
bit? Okay.
About right there.
Okay, so when you're looking at it,
So I'm standing, if I'm outside the driver door right now, conducting my stop, this is exactly as I see it, with the bag of marijuana sitting right here in front.
okay, so the marijuana is here, the firearms that you see are on top of one another.
Correct.
Okay, and they're, I guess, by her, you know,
Yeah,
replaced
about
by
left.
my thigh, my left thigh,
Correct.
closer to my behind. Okay, so the magazine, then, where's the magazine?
The magazine would have been sitting right here.
Okay, so behind that.
Correct.
Okay. So the magazine's back here, then the two firearms, then the marijuana here.
Correct.
Okay. And in terms of where the defendant is seated, and there being the center console, is there anything obstructing between his seat and the passenger seat?
No.
Any obstruction here whatsoever?
No.
But here, I mean, in the middle where that center console is.
Correct.
Okay. All right, thank you.
Thank you.
Now, not only was there an observation then of the magazine, the firearms, and the marijuana that were here, there was something else in the car that you talked about. And on the floor, correct?
Correct.
What was that?
That was the loose 10 millimeter round.
when you talked yesterday about that, and about Stacy and her state of how she was talking, when she's talking to you in the vehicle, and she's situated there, when does she tell you about these two firearms?
Right after I asked her if there was any thing illegal in the vehicle, any guns, knives, drugs, anything I need to be concerned about.
Okay, so after that, she tells you that.
Correct.
You were shining your lights on that simultaneously?
Correct.
Okay.
At the same time she's answering, I'm hitting my flashlight and seeing the firearm sign.
When you go to pull over the vehicle, how long are your lights on before the actual stop?
So I activated my lights just as it was about to, or actually just as it was pulling onto Richmond, so seconds,
Okay, and then how far down the road did you travel?
maybe 100 feet or so.
Okay, and during this period of time and looking at the back window, were you able to see into the vehicle?
No,
So you're not able to see what's going on in there?
no,
At this point in time, do you even know if there's more than one person?
no.
Now, Mr. Hinton also asked you about the conversation that you had with Stacy, and her nervousness, and did you think that it was the nervousness because she's being pulled over, she's in the car, she has the firearms? Based on your conversation with Stacy, is that why she was nervous?
It didn't appear.
Objection.
Hang on. Sustain.
Did Stacy tell you that she was nervous about the fact that she'd been pulled over?
Objection.
Sustain.
Without saying anything that she said, did she give you a clear reason why she was nervous that day?
Objection.
I'll allow that question overruled. Just yes or no.
No.
But you did note a difference in her demeanor, being in front of the defendant versus not being with the defendant.
Objection.
Sustain.
Was there a difference in her
Objection.
demeanor?
Overruled.
Could you repeat the question, please?
Was there a difference in her demeanor?
Yes.
And this is not a case of a concealed firearm, right?
Correct.
In the way that things were situated on the seat of this car, did you find that to be unusual?
Yes.
Why?
Because that's not the way that normally when we encounter individuals with firearms in the vehicle that they're being carried.
And were both of the magazines there?
I'm sorry?
Were both of the magazines sitting on the seat?
No.
And the round that was on the floor belonged to which firearm?
The 10 millimeter.
The fact that those firearms were sitting where they were, and there's a round on the floor, based on your training experience, what was that consistent with for you? What did you believe had occurred?
I had a suspicion that the operator had tampered with the one of the firearms in some way or given it to the passenger.
And why did you think that?
Because again, that's not the way normally firearms are being positioned. They're not the normal way firearms are being carried, especially under this new constitutional carry law. And just the circumstances all around this were off.
And how many times have you dealt with magazines and firearms?
A lot.
When you've dealt with magazines like this one here from Stacy's Exhibit 2, when you've dealt with magazines like this, and the ammunition is in there, does it just like fall out?
No,
And in this particular one, would it just like fall out if you just moved it around?
no.
When ammunition is ejected from a firearm, tell me how that happens. If I'm in the car and I'm going to eject a round out, where's it going to go and how's that going to happen?
So with firearms, the either spent or live casing will be ejected to the right.
Ejected to the right.
Yes,
Okay. And if the ammunition is in the magazine and you're going to clear the firearm, is that going to be ejected to the right? If it's just in the magazine,
no,
where does it have to be in order for it to be ejected like that?
in the chamber,
So loaded.
correct.
And Mr. Hinton asked you some questions about going back and talking to Stacy again and asking her questions about where she had been, but you did ask her that, right?
Yes,
And the answer that she gave yesterday, was that consistent with what she told you at the scene?
no,
And what she said yesterday about what had happened with the firearms, was that consistent with what she told you at the scene?
no,
And when she told you what happened at the scene, she was not with Mr. Robinson at that time. She was not in front of him when she told you that.
correct.
Yesterday, when she talked here in court, she was in front of the defendant.
Correct.
I have nothing further, thank you, Your Honor.
Recross-examination.
Sorry.
Just Stan will get that.
Okay.
Well, I was gonna reference them. I can't read. Officer, is your testimony that these two chairs resemble the chairs that were in a car?
They're consistent, it's not exact.
Wasn't there a higher back on a car seat?
Correct.
And aren't they structured a bit different?
A bit.
Now, in this situation, there was something between the two seats. This wasn't a bench seat, correct?
I'm sorry?
In the vehicle, there was something in between the two seats. This was not a bench seat where someone could sit in the middle, right?
Correct.
And there's cup holders, right?
Correct.
Probably some center console,
Correct.
maybe like a parking brake or a gear shifter, something of that nature.
Yes.
And there were items in the cup holder, right?
I don't recall.
Weren't you investigating as to whether or not there was any type of open container or any type of alcohol in the cups, or at least one of the cups in the center console?
I do recall that, yes.
Okay. So in addition to what's normally there by virtue of the make of the car, there were additional things in between Stacy and Lorenzo, correct?
Yes.
Now, you had indicated, again, during your most recent questioning that the positioning of the weapons was odd to you.
Yes.
Right? You said that a lot of times folks will have the firearm on them, right?
I did not say that.
Did you?
I
what
said
did
they'll
you
have
say?
them in a vehicle with them.
Okay. And when you've encountered situations where someone has a gun that they're not supposed to, a lot of times it's hidden somewhere in the car, right?
Yes.
It's not just sitting right there, correct?
Sometimes, yes.
And although you asked whether or not there was anything weapon-wise in the car before Stacy responded, that's the first thing you said right when you walked up to the window, right?
I'm sorry, could you repeat that? I'm sorry,
So Stacy had indicated to you that there were the 2 weapons in the vehicle.
Yes, when I asked, yes.
Right? It was after you asked, right?
Correct.
But you asked right when you got up to the window. That was the first thing you said.
One of the first things.
So it's not like a long period of time went by before this was revealed to you.
No.
And you said this was a high crime area that you were patrolling,
Yes.
and this was near Nebraska Street?
Yes.
And you heard Stacy testify yesterday that she lives on Nebraska Street?
Yes.
You had indicated during your most recent questioning that for a reason or reasons you didn't have the scale tested for fingerprints or DNA, right?
Correct.
But if you pull somebody over and they tell you, hey, this is a bag of cocaine or this is a bag of heroin, you still have that tested, right?
If they they were to hand me it and say this is what this is?
Correct.
No.
Well, you've had situations prior to marijuana being legal where you would submit marijuana to be tested in the lab, correct?
Only for juvenile cases.
Now, in these pictures, so 10C and 3D, you're wearing gloves in both of those pictures, right?
Yes.
And you're wearing gloves so that your fingerprints don't get on those items, right?
Correct.
And the scale was submitted to the lab for testing for drug residue, right?
Correct.
And that's the same lab that would test items for prints and DNA?
Yes. Yes.
And there were a lot of questions about Stacy's demeanor. Do you recall that?
Yes.
And you had indicated that this was a cold night, correct?
Correct.
And did you have the heat on in your cruiser?
Probably.
Okay. So you noticed a difference in Stacy's demeanor from when you were talking to her on the side of the road in very cold weather compared to when you had her in your cruiser out of the elements, right?
Yes.
And some time had passed as well, right?
Yes.
You had indicated that you didn't feel the need to follow up with Stacy at all,
Correct.
but isn't it accurate that on August 29, 2025, not even a week ago, Officer Witt did some follow-up in regards to this investigation?
At the request of the prosecutor's office, yes.
And that follow-up was to respond to grab and go?
Yes.
But there wasn't any follow-up to check the footage of Falcones or anywhere else to check to see if what Stacy was saying was accurate, right?
No.
And again, you didn't take the opportunity to speak with her again out of the heat of the moment to hear her side of things, right?
Correct.
Thank you.
Thank you.
You may return to your seat, sir.
Thank you, sir.
Statement call its next witness.
Your Honor, the state would call Becca Silverstein.
Yes, thank you.
Good morning. raise your right hand. You swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
And see. Turn off when you're ready.
Thank you, Your Honor. Please introduce yourself to the jury and spell your last name for the record.
Rebecca Silverstein Gross. It's SILVERSTEIN-GROCE.
Are you employed?
Yes,
And where are you employed?
I employed at the Lake County Crime Lab.
And how long have you been employed there?
I've been at the laboratory a little over 13 years.
What's your current position there?
I am the Firearms and Latent Print Section's technical leader.
Could you repeat that?
Yes. I'm the technical leader in the Firearms and Latent Print Sections.
And prior to joining the Lake County Crime Lab, did you work anywhere else?
No, I've been employed with the Lake County Crime Lab was my first professional job.
Please outline your education that qualifies you for those positions that you just mentioned.
Yes. So I have a Bachelor of Science in Forensic Biology with a minor in Chemistry from Ohio Northern University, where I completed an internship with the Ohio Bureau of Criminal Identification. And then upon employment, I completed approximately 18-month training, on-site training for latent print analysis, and a little over 2 years training for firearms analysis.
And what type of certifications do you hold?
I am certified by the American Board of Criminalistics in Comprehensive Criminalistics.
And are you a member of any professional organizations?
Yes, I'm a member of the Midwestern Association of Forensic Scientists, the International Association for Forensic Science, for Identification, the IAI, the Ohio Identification Officers Association, which is the Ohio division of the IAI, the Association of Firearm and Tool Mark Examiners, and the American Board of Criminalistics.
And when you joined the Lake County Crime Lab, what training did you undergo there?
Yes, so for my latent print training, I completed approximately 18 months of training that brought me up to speed on our laboratory policies and procedures, the background of the use of latent prints as a means of identification in the forensic science field. I completed readings, practical exercises, competency tests, and a competency testing prior to being signed off on casework. In addition to the on-site training, I also attended training classes and conferences as a part of my training as well. For firearms, I completed that training following my latent print training. That included on-site training for laboratory procedures and the basics of firearms analysis. The backbone of my training was I participated in the ATF's National Firearms Examiner Academy from 2013 to 2014. Is a year-long program set up essentially like an accelerated master's program where I completed 4 different stages, including readings, papers, a research project, 17 weeks of on-site training at the ATF laboratory in Maryland, manufacturing tours and firearms, tools, and ammunition, and then as well as moot court testimony of the mock cases that I completed in addition to my research project.
And in addition to all the training experience that you just mentioned, do you do any continuing education?
Yes. So in addition to my training, and even after completion of training, we participate in continuing education. So at least once a year, I participate in either a workshop, a training class, attend a conference, participate in a webinar. I also do continuing education through reading journal articles to stay up to date on the developments in the field.
And through the course of your work at the Lake County Crime Lab, have you testified as an expert before?
Yes, I have.
And in which courts?
In Lake County Common Pleas and Lake County Juvenile Courts.
Approximately how many times?
Approximately 30 times or more.
I want to talk to you a little bit about lab accreditation. In general, what is the Lake County Crime Lab?
So the Lake County Crime Lab is a forensic testing laboratory. We test forensic evidence in the areas of DNA, trace evidence, drug chemistry, toxicology, laden prints, and firearms.
And is the Lake County Crime Lab an accredited lab? Yes,
so we are accredited as a forensic testing laboratory through ANAB. This is under ISO 17025, and this accreditation is a period. We are something that we are. Excuse me. The accreditation is shows that we have our policies and procedures. Are set up so that we adhere to the standards that are set forth by the accreditation body, and that we are doing what we say our policies and procedures say that we are doing. It is a 4-year accreditation period, so every 4 years the accrediting body will come and do a full reassessment of the laboratory, looking at every section of the laboratory in detail. And in addition to that ANAB accreditation as well, our DNA section is also accredited by the FBI quality assurance standards as well.
And how long has the Lake County Crime Lab been accredited?
We have been an accredited laboratory since 2000. We've been an internationally accredited laboratory since 2009.
And has there been any types of breaks in accreditation?
No, there have not.
Now, for the jury, can you explain the process that occurs when evidence is submitted to the crime lab?
Yes. So at the Lake County Crime Lab, we receive evidence from police agencies submitted for analysis. When an agency brings a case for submission, they're required to complete a submission form. On the submission form, they're asked to fill in the agency's relevant case information, and the items that they will be submitting to the laboratory, as well as what disciplines they would like each item to be sent to, and what types of analysis they want completed. So when the evidence that they bring in must be properly sealed with initials and showing that it is properly sealed. If it's not, our evidence custodians will ask for it to be sealed prior to it being submitted. The case is then entered into our laboratory information management system, or our LIMS system, where it will generate a new case number, would generally be the next case number on the list if it's a new case that's being submitted. And each individual evidence item will get its own item number within that case number. In addition to that, each item number getting its own number, it gets a associated barcode label with that. That barcode label is what we utilize to track the evidence throughout the laboratory. It's the chain of custody for the evidence. So that barcode is scanned anytime that evidence is transferred from one location to an individual, or from individual to individual. That it's scanned to document the handling of the evidence and its path throughout the laboratory. Each individual has their own barcode as well, with their own code, so that no individual can transfer evidence under another individual's name. Once all of the evidence has been, the barcodes have been added to it, it's been entered in, that evidence is then transferred to our secure evidence locker, and a folder is created for the case until it's ready to be worked.
And what is the secure evidence locker?
Is the location in the laboratory where the evidence is secured, so it has access only by laboratory employees.
And would the crime lab accept anything if it was not properly packaged?
No. There may be some exceptions, but it would have to be brought forth prior to it being submitted. But generally, no. If we'll ask to have it properly sealed prior to it being submitted. So, which the evidence custodians or the individuals bringing in the evidence as well can do at the laboratory before transferring it into the custody of the laboratory.
And did you receive any items in regards to this case?
Yes, I did.
And do you recall what those items were?
I received 2 firearms to process.
And when you go and get a firearm, what's the first thing that you do?
So I check the case to see how many items of evidence there are, where they're located in our evidence locker. When I retrieve those items, I transfer those items into my custody by scanning my evidence barcode, or scanning from the location to my evidence barcode, and then scanning the barcode of each of the items that I'm transferring. Then I will examine the packaging of the item, the seals of the item, to make sure that it is still properly sealed. And then if that's the case, I will date an initial next to our evidence barcode, showing that's the date that I opened the evidence for analysis.
Your Honor, may I approach?
You may.
Showing the witness was previously marked as State's Exhibit 6. Can you tell me what that is?
This is a copy of the evidence submission form in this case.
And what individual's name is that submitted under?
The case name?
The case name.
The case name is Lorenzo L. Robinson.
And is there a laboratory case number on there?
Yes, there is.
And I know you talked a little bit about what you received for testing, but what was submitted to the lab for testing?
In addition to the 2 firearms, there was a digital scale that was received as well.
Ms. Sorstein, what's that exhibit number again, please? I'm sorry. You have it?
6, Your Honor.
6, thank you.
Your Honor, may I approach again?
You may continue to approach.
I'm showing defense counsel was previously been marked as State's Exhibit 4A through 4A to 4B and 5A to 5B. I apologize, Your Honor. There was evidence of item 4C in there as well.
Okay.
Ms. Silverstein, can you tell me what those are?
These are the documentation photos I took of the evidence that I processed.
And are those true and accurate copies of the photos that you took?
Yes, it is.
And are those the items that you referred to that were submitted for testing?
Yes.
I'm going to hand you what's previously been marked as State's Exhibit 1A and 1B. And can you tell me what that is?
State's Exhibit 1 is our item number 1, as you can tell by our laboratory barcode with my initials and date next to the barcode, which contains just verifying firearms unloaded, contains one of the firearm, item 1, the firearm, and the magazine and ammunition that I received in this case.
And are your initials on that box?
Yes.
And why are they on that box? Why are they on that box?
Why are the box? Apologies. They are on the box they indicate the date that I opened it for analysis as well, that the seals were intact when I opened it.
I'm now showing you what's previously marked as State's Exhibit 2 and 2A. Can you tell me what that is?
State's Exhibit 2 and 2A is our laboratory number. Item 2 you can tell by the laboratory barcode with my initials and date next to the barcode, which it can also contains firearm is unloaded. Contains the second firearm with the magazine and ammunition that I analyzed in this case.
And what is the case number on both of those boxes?
Our laboratory case number is 25-000133.
And what's inside of the envelope in those boxes?
Inside the envelope, yes. So, State's Exhibit Item 1A. Some gloves on. State's Exhibit 1A contains the firearm magazine, as well as the ammunition that was received, and it also contains the additional envelope with one additional round of ammunition that was submitted with the firearm.
And the other box?
So the envelope in State's Exhibit 2 is laboratory, has the barcode, it's laboratory item 2B. Contains the ammunition from the magazine that was submitted in this case. And 2B is also the magazine.
And are you able to see the serial number on those firearms?
Yes.
And can you read them for the record, please?
Okay, so State's Exhibit 1, which is our laboratory item 1, the serial number on this firearm is BB571388.
And the other firearm?
And also for reference, the serial number plate is located on both these firearms, is located right on the frame here underneath. The serial number on State's Exhibit 2, our laboratory item number 2, is BF 396308.
And previously, we talked a little bit about the process when items come to the Lake County Crime Lab. Was that process followed in this when you received this evidence?
Yes.
Now, what's the first thing that you do when you receive firearms?
So in this case, these firearms were submitted for latent print processing as well as firearms analysis. So the first thing I did with each of these firearms was actually take these documentation photos, and then I processed each of them for latent prints.
I want to talk a little bit about latent prints. Can you explain what those are?
Yes. Latent print, latent essentially means invisible. So they are visible, they're reproductions of what is called your friction ridge skin. So on the tips of your fingers, all the way down the palms of your hands, you'll notice you have like ridge skin. It's called friction ridge skin. Essentially, it's there designed to help us grip things, handle things. But what if we didn't have that? May not have it, be able to hold on to things as well as we did with that. So that's what the skin is designed. And you can see that ridge skin is only on the surface of your hands, your palms, as well as the soles of your feet and your toes. So when you're handling anything with your bare hands, you may have sweat, oils, any other residues from items that you may have handled that may get transferred to an item when you handle it, when you touch it. If you've noticed on your cell phone screens, on windows, you may see impressions from your fingers on there. They're made that can be made up of any combination of those types of residues. They're also very fragile, so they're easily wiped away. If you see, you can wipe right through them. So we utilize to visualize those latent prints. We have to do tape development methods to be able to visualize them.
And did you find any latent prints of these firearms?
I did not develop any latent prints that were suitable for comparison on either laboratory item 1 or laboratory item 2.
Now, can you talk about, you said suitable for comparison. What does that mean?
So suitable for comparison, meaning that there's enough. So with the latent print, if we do develop one, we're looking at 3 levels of detail. So the first level of detail is going to be the ridge flow, or what area, if we can tell what area of skin that came from, whether it's a finger or a palm or maybe some other surface like the foot. That's the level 1 detail, as well as the pattern types. If you've seen on the tips of your fingers, there's 3 pattern types that can be seen on the tips of your fingers: loops, whorls, or arches. You can have any combination of those or all of the same type. That's all what's considered level 1. That's just a general class characteristic. This is from a finger. This is a whorl. Then we go down to looking at level 2 detail. Level 2 detail are going to be the individual ridge events, ridge characteristics that happen within those patterns. So places where your ridges stop, places where your ridges come together or split in two, or you have enclosures or short ridges. Those can be in any combination all throughout that pattern. That's where you can start to differentiate one whorl pattern from another whorl pattern, or one looping pattern from another looping pattern. And then the third level of detail that we look at in our analysis are things like shapes of the edges of the ridges, sweat pores if they're present in our questioned or latent print, any maybe creases or scars that may be present. All of that is additional information that we utilize to determine whether or not a latent print is suitable for comparison. If there's enough of that information present that we can compare it to a known record, which is a record of all 10 rolls of all 10 of your fingers, flat impressions of all 10 of your fingers, and also generally includes palms as well.
Now, what are some things that typically determine whether a fingerprint's going to be left behind?
There's a multitude of factors. One being the condition of your hands. If your hands are very dry, you're less likely to potentially leave prints behind when you handle it. You may not have any of those sweat, oils, or anything on that surface. If you're wearing gloves, there's some type of intermediate object between your ridged skin and the object that you're handling or you're touching. The surface of the item as well. Some surfaces are more conducive to the development of latent prints than others. Surfaces like windows, your cell phone screens have that kind of smooth, flat surface, which is a little bit more conducive than some example surfaces like a plastic surface. Like a lot of the surfaces in your car that are kind of a plastic or a polymer have that light texture, or like the edges of a TV or a computer monitor have that light texture. They're generally designed not to be conducive to leaving, at least to show latent prints, which is less likely to develop latent prints on those surfaces because of that light. Even that light texture can have an effect. Doesn't necessarily mean that you won't develop prints on that surface, but it is a little bit more difficult. Depending on weather conditions, how they're handled, latent prints are very fragile, so even if maybe there was a print on the surface, if there's such subject to like frictions, it's rubbed against something, that also could potentially eliminate anything that may have been there or may not have been there either.
Are firearms typically conducive to latent prints?
It depends on the firearm, but generally, for example, the types, the firearms that we received in this case, we don't develop latent prints. Very often to that. There's probably less than 10 times since I've worked at the lab that we have developed a latent print on a firearm, on this type of firearm, that is suitable for comparison. Now, if you notice with these, with the magazines in these firearms, if anything on a firearm, especially like this, the metal surface of like a magazine like this, kind of a smooth, glossy surface, is a little bit is much more conducive. So if we were to develop a fingerprint, it more likely would be on that surface, but it doesn't mean it would only be on that surface.
And you said it in your 13 years, there's been prints on a firearm of that nature about 10 times?
I did my best estimate, at least in the last 5 to 6 years.
So can you explain the testing process for latent prints on those firearms?
Yes. So for each of these firearms and the magazines as well, I processed these utilizing cyanoacrylate ester fuming or superglue fuming. So essentially, the superglue that we utilize is the same that you can buy in the store. It just doesn't dry as quickly, so that we can handle it, work with it a little bit more, because we're not utilizing it to put things back together. So we place a metal dish with some superglue in it. And actually, these ones, because they're firearms, we have a vacuum superglue chamber, so under vacuum pressure, we place the superglue in the chamber. It's heated. There's heat applied, and then under vacuum pressure, the vapors from that the superglue, as it's heated, adhere to any residues that may be on the surface of whatever item is in there. So in this case, these were the firearms. If there were residues, those the super glue would adhere to those surfaces and essentially polymerize. So what that means is like it would kind of harden and create like a protective layer that, where if I didn't treat it and I wiped a fingerprint, a latent print off of there, it would wipe away. With the super glue is less likely that as long as it's dry, it protects it, so we can then do further processing methods. Obviously, we're not handling the items to test like that. We do controls and test the controls to make sure that everything is working properly throughout the process of processing these. So I super glue fume these first, and then I process them with white and or black fingerprint powders.
And when you're finished with your testing, do you write a report?
Yes, I do. I document with notes and throughout, and then finalize with the report.
Now showing opposing counsel with remarks to the State's Exhibit 8. You have in front of you there, the State's Exhibit 8. Can you tell me what that is?
State's Exhibit 8 is a copy, these are multiple copies of the fingerprint report I generated in this case.
And is that a fair and accurate copy of your
Yes.
report? Now, what other testing did you perform on the firearms?
Following fingerprints?
Yes.
Yes. So following fingerprint analysis, I processed each of these firearms for operability. So for our operability testing, we are looking at each of the firearms, documenting basic information about each make, manufacturer, model, serial number, and then documenting how it operates by doing a series of what we call bench testing. So this is all done without any ammunition in the firearm. We work the action of the firearm. We test to see how it functions. And we also test if there's any safeties on it. The safeties are, if they're present and if they're functioning properly. We will take essentially what we call is dummy ammunition, or essentially unloaded ammunition that is same shape and size as a loaded cartridge. We'll run those through to test. Test the action of the firearm, make sure everything cycles smoothly through the firearm. We test the magazine capacity. Test the magazine capacity of the firearm. Identify any of the ammunition that's submitted, what caliber it is. Same with the firearms, what caliber it is, making sure that the ammunition that's submitted with that firearm is compatible with that firearm. We'll do all this testing, documenting the findings of those tests, how it operates. Whether it's single action, double action, in this case, and what single action, double action is is essentially how the firearm functions. So single action is one action is being performed that when the trigger is pulled to make the firearm discharge. So if the trigger is pulled, one action would be releasing the striker in the case of these firearms, which is the firing pin. Double action would be that it's essentially cocking the striker and then releasing the striker, so that'd be two actions that are being performed. I finalize all those tests in my notes, and then once I determine magazine capacity and that it's functioning, I will also do a one more test I do before we move to test firing with live ammunition. We do a pencil test to make sure that the firing pin would strike a primer if there was a cartridge loaded into the chamber. And then we prepare the firearm for test firing. So with test firing, we will try to utilize submitted ammunition if possible. A magazine that was submitted with the firearm, and then we'll use two rounds of laboratory ammunition. We try to test firearm with 3 rounds of ammunition when it's submitted.
And did you perform that testing on both of those firearms up there?
Yes, I did.
And what were the results of that?
Both firearms tested as operable.
And do you write your findings down anywhere?
Yes, I documented that in notes as well as in the final report.
Now showing who the council was previously marked as States Exhibit 7.
Thank you.
Can you tell me what States Exhibit 7 is?
State's Exhibit 7 is a copy of the firearms report I produced in this case.
Now, those firearms up there, especially the 10 millimeter, would that be capable of killing somebody?
Regardless of caliber on both of these, they both have the potential to cause lethal damage. Yes.
Now, I want to talk a little bit about the difference between 9 millimeter and 10 millimeter. Would the ammo from the 9 millimeter be able to function inside the 10 millimeter?
So, may I show to each of the rounds? I'll need to open this one.
Can I see council for a second? All right, you may continue.
So the last question was if a 9 millimeter round would work in a 10 millimeter firearm.
It's not impossible for it to discharge, but it would be if it's a smaller cartridge than a 10 millimeter round. So it would potentially have to be manipulated for it to go off in a 9 millimeter to go off in a 10 millimeter firearm.
Now, can you compare the lab number on the boxes to the evidence submission form?
So our laboratory case number on each of the evidence barcodes on the box is 25-000133. The laboratory case number on the evidence submission form is 25-000133.
And would a 10 millimeter round, would that fit in a 9 millimeter gun?
It would not.
So if you touch a firearm with your hand, would that mean that there's prints on that firearm?
Not necessarily. I mean, again, it depends on the surface, the type of surface the firearm is, the material that it's made out of, the condition of your hands, whether there's any intervening object, you're wearing gloves or something like that. Just because you touch a firearm doesn't necessarily mean you'll leave any latent print detail behind.
Now, when we watch things on TV like CSI, there are prints kind of everywhere. Is that typically your experience of working at the crime lab? Not to the extent that they essentially glamorize it on TV. There are many items that we don't develop any latent print detail on. There's many items that we develop latent print detail on that's just not suitable for comparison. And then there are items that we develop suitable prints that are suitable for comparison on. So it's a combination of the level of development. And did you find any prints on the magazines?
So the only magazine that I developed some ridge detail on was the magazine for the 9 millimeter firearm, which is State's Exhibit 2.
May I have a moment, Your Honor?
Yes.
No further questions, Your Honor.
Cross-examination, Mr. Hinton.
Thank you, Your Honor. Good
Hi.
afternoon.
Good afternoon.
You indicated that this was laboratory case number 25-000133, is that correct?
Yes.
And then next to that in parentheses, and I'm looking at your report, it says 0004, is that right?
Yes, that's the request number.
The 0004 is the request number?
Yes.
So as far as the 25-000133, what does that mean? How is that number created?
Yeah, so that is when the case is brought in for submission at the laboratory, that item is automatically generated as the next case number up. So they just select to create a new case if that's what the case, if they're submitting new evidence. So that's just the next laboratory case number that's up, and that's assigned to the entire case and is on each of the reports.
And that would be for any item that was submitted to the laboratory, correct?
Yes, so any item, any case, so that's the case number, and then each individual item has its own item number, and then depending on what types of analysis that the agency wants done, each different type of analysis will have a request number, which starts with 0001, and then additional following that.
And what's the most common item that's submitted to the crime lab for testing? Is it drugs, narcotics?
I can't say for sure. I don't have the numbers on.
Out of those 133 different cases that were submitted, not all of those involved guns, correct?
Correct.
Okay, a lot of them did not involve guns, correct?
To my knowledge, I mean, we did at this point. This was submitted at the beginning of February. At that point, we did not have over 100 firearms cases.
So when you say that, that there's a certain number of guns that had fingerprints come back on them, you really don't test that many guns, do you?
We test at least a couple hundred, every the past few years.
Now, you had indicated that you tested both firearms, the 9mm and the 10mm, right?
Yes.
Both magazines, the one for the 9mm and the one for the 10mm, correct?
Correct.
And also the 10mm bullet, correct?
For latent print processing, or yes. So in latent print processing, everything was superglued, and then the only thing I did not use black powder on were the 9mm rounds. So I did the 10mm cartridges. The 9mm cartridges, just due to their size, they're small, much smaller than the 10mm. I did not, just because of the surface area, I didn't do powder on them, but they were superglued.
And you didn't recover any latent prints on the 10mm round?
Correct.
As far as the 9mm magazine, you indicated that you did recover latent prints, correct?
Yeah, there was some latent print detail on it, yes.
Do we know whose prints those were?
It was not suitable for comparison to a known record.
So out of everything you tested for fingerprints, Lorenzo Robinson's fingerprints were not found on anything, correct?
Correct.
Thank you.
Redirect examination.
Nothing else, Your Honor.
All right, you may step down. Thank you.
Thank you.
Ladies and gentlemen, we'll break for lunch. Please remember the admonitions that I've given you. Don't talk about the case with each other, with anyone else. Please don't let anyone talk about it with you or in your presence, and no investigating or researching any issues involved in this case. We'll break for an hour and get back about 10 after, and hopefully we'll all get back here in here by quarter after. So enjoy your lunch.
All rise.
time did the judge say to come back?
Ten after is the latest. Actually, I'd go back here at 1.
Okay.
We should be good.
I'm gonna boogie, I'll be back.
Okay, be back around 1-ish? Yeah, okay.
12:45.
Sure, I don't have anything here. 3 more officers and 2 more lab techs. 5 more witnesses.
Well, I mean, it should be quick.
Okay.
Josh, what number is this? I mean, it doesn't have a sticker, does it?
Crime lab.
I know it's a crime lab.
Oh, I should have one. I should have a sticker. Which one is that? Are there should be 2 reports
Firearms
there.
or fingerprints?
Is there an extra one?
Yeah, well, there was.
Is that what it is? It's one after, oh, there it is, okay. Okay. You can have that one then.
Okay, so we're gonna have to take velocity later. So wit, I would have to take that one. Alright, so
All right, Ms. Linden, whenever you're set.
Thank you, Your Honor. Officer, if you could please introduce yourself to the jury, spell your first name and your last name for the record.
Yes. Hi, my name is Officer Corey Witt. My first name is Cory. Last name Witt, Whitt.
Okay, where are you employed?
Painesville City Police Department.
And in what capacity?
I'm a certified police officer through the state of Ohio.
Any other prior law enforcement experience?
Yes.
Where?
I worked at Willoughby Hills, Fairport Harbor, and Perry Village Police Department.
How long have you been with Painesville?
About 8.5 years.
And with Painesville, if you could, and any other police departments you work with, is there specialized training that you need to have in order to be a certified police officer in the state of Ohio?
Yes.
What kind of training did you have?
I completed the Ohio Police Academy and continuing training through our department and through the state.
And have you gone through training with a field officer, field training officer?
Yes.
Okay. And have you done any other specialized training regarding firearms or narcotics?
Yes.
Can you please explain that for the jury?
Yes, I'm a certified range instructor for pistol and rifle, and I've had training with narcotics such as drug operations and on the field.
Thank you.
Oh, bless you.
Thank you.
And on the field as well, experience.
And any specific classes or training regarding the identification of narcotics, what they look like,
Yes,
and what kind of training do you have?
the drug identification.
And what is that? What does that mean?
So there's a instructor who is obviously certified with narcotics, and he'll tell us about what the narcotics are, what they look like, and sometimes what they smell like.
And with regard to your work as a certified peace officer in the state of Ohio, approximately how many times have you come in contact with illegal drugs?
Some would say a lot, but I'd say at least over 50 to at least 100 in that range.
50 to 100? And what about dealing with powdered things like powdered cocaine? Have you come in contact with that before?
Yes,
And have you been able to identify that by looking at it?
yes.
And regarding firearms, you said that you have some specialized training there. What specific training do you have, and why do you have that training?
I'm a certified instructor for pistol that acquired a week class down at Opata. Gives me the capability to certify police officers for qualifications in the pistol and the rifle. And I'm also a rifle armor and shotgun armor.
I want to direct you to January 31st of this year. Were you working that day?
Yes,
What shift and hours would you have been working?
I was working midnight shift, which is 7 p.m. to 7 a.m.
And do you recall if anyone else was working with you on that same shift?
Yes,
And who was working with you that evening?
Officer McLeod.
On that particular night, what were your duties?
My duties is for calls of service, investigate traffic and criminal.
Were you in any particular zone that evening?
I was working the north side.
And were you dressed in uniform as you are today and in a marked patrol car?
Yes,
On that particular date, did you end up coming in contact with the defendant in this matter, Lorenzo Robinson?
I did.
Can you explain for the jury how that happened?
Yes, I assisted Officer McLeod on a traffic stop.
And specifically, well, let's go back for a second. Around what time was that when that happened?
That's around about 10, almost 11 p.m.
Okay. And was it light out, dark out?
It was dark and very cold.
Okay. And on that date, did you respond immediately with him?
Yes.
Okay. Tell me what you observed as you responded to the area.
So again, I was working the north side. I was in the area of Richmond, Nebraska Street. That's one of our crime areas. A black Chevy was driving down Nebraska going to Richmond, and Officer McLeod observed a traffic violation, and I was immediately able to get behind him.
Okay. And did you observe at any point in time that same Chevy Trax vehicle?
Yes, it was going westbound as I was going eastbound on Nebraska when it passed me.
So when it went past you, were you able to see inside the vehicle?
I was.
Okay. What could you see?
I saw, I don't know if it was a male or female, it was a person that was wearing a ski mask that was operating the black Chevy.
Okay. And could you see if there was anybody else in the vehicle at that time?
I wasn't, no. I saw the operator.
And was that a description that was given to you by Officer McLeod, or is that what you actually observed yourself?
That's what I observed.
And then when you came up behind Officer McLeod on the stop, what did you do?
I approached the vehicle on the passenger side, and the passenger was a female who I know as Stacy Reichert.
Okay. And did you, when you came up to the passenger side, what was the purpose of you being on the passenger side of the vehicle?
The purpose is for foremost officer safety. We want to make sure our officers are safe. It's protocol to back our officers up around that time, especially in that area.
All right. What, if anything, did you observe when you came up to that passenger side window where Stacy Reichert was?
Met with Stacy, and she was kind of sitting in like an abnormal position. She was kind of had her leg up a little bit slightly, and then had her body more towards the passenger door, which typically in my experience isn't usual. It means they probably have something under them, or trying to, hide something.
Okay, so from what you're observing, it looks like maybe she's sitting kind of off.
Odd, yeah.
Okay. And so when you see that she's sitting in that manner, is there anything that you do about it?
Officer McLeod had asked if there was any weapons in the vehicle, and Stacy informed us that there was 2 firearms inside the vehicle.
Were you able to see this?
Not at that time, no.
Okay. And so then what happened?
So when Officer McLeod asked that, we asked Stacy to step out of the vehicle, and then she stepped out of the vehicle, and that's when I observed the 2 firearms, and then we had her step back to the vehicle while Officer McLeod was still speaking with Lorenzo.
And what, if anything, did you see on the passenger seat of the car?
Passenger seat, observed the 2 firearms, which were later a Springfield 9mm and a Springfield 10mm, and then there was also a bag of marijuana inside the car.
And could you tell why it was that Stacy Reichert was kind of sitting funny? Was there...
Found that there was 2 firearms sitting underneath her buttocks and by her left leg.
Okay. And were you able to find a magazine to that at all?
And there was also a magazine on the passenger seat as well.
Okay, so magazine, marijuana, and 2 firearms.
Yes, the magazine wasn't inserted in the firearm, it was separate next to the 2 firearms.
Okay, was there anything else that you located in that side of the vehicle?
Yes, there was a chambered 10mm round on the passenger floorboard, more towards the center console. And then we also later found a digital scale underneath the driver's seat that had white powder residue on it.
Okay, and who was the driver of the vehicle that evening?
That was Lorenzo Robinson.
Okay, and is that person in the courtroom here today?
He is. He's in the blue plaid shirt, sitting with the defense.
May the record reflect that identification, Your Honor?
Record may so reflect.
Thank you. So you talked about 2 firearms that were there. I'm going to show you what's previously been marked as, I'll start with State's Exhibit 1. When you look at State's Exhibit 1, tell me when you're looking at the outside of the box, do you know what that is?
I do.
Okay, what is that?
That is our packaging that we have of our evidence room, and I noticed that my initials outside the box.
Why are your initials on the outside of the box?
I was the one who packaged the firearm.
Okay, so how did it come to you to be packaged by you?
I was the one who had placed them in a patrol vehicle, then they were brought back to the station, and then into the evidence room, and then that's when they were packaged.
So these are, when we see the CW around here, these are your initials.
Those are my initials, correct.
And then inside, if you could look inside and look through what we have here, and tell me if you recognize what those items are.
Am I allowed to touch the packaging?
Yeah. And then looking inside the bag, if you can see inside there as well.
It's the 10mm Springfield that was on the seat with a magazine and bullets inside of it.
Okay, and the bullets that you're talking about, were they in the magazine?
Yes.
Okay, so they were in the magazine on the seat, and the other round was where?
It was chambered. Oh, I'm sorry. There was a single round on the passenger side floorboard.
Okay, all right, not in that magazine.
It was not in the magazine, no.
And is this the same firearm that you observed back on the 31st?
Yes.
And how is it that you know that it's the same one?
It's the same one I observed, and it's the same one that's packaged inside the box that I packaged.
And same with State's Exhibit 2, same type of box, your initials,
Yes.
okay. Interior, you recognize that?
Yes.
And how is it that you recognize that?
That's the Springfield that I observed on scene and that I later packaged.
And that, what caliber is that one?
That is a 9mm Springfield.
And you also then, there's a magazine in here, you also collected that?
Yes.
And did that have rounds in it as well?
Yes.
Ammunition? Now, you also mentioned that there was a scale that you found, or that was found. Who found the scale?
Officer Belowski found the scale.
Okay, and Officer Vlasky, were you there when he found the scale?
Yes,
And did you have an opportunity to look at the scale?
I did.
Okay. And I'm going to show you what's been marked as State's Exhibit 9. I'm going to ask you to take a look at that, if you recognize what that is.
Yes, I do.
And how is it that you recognize that?
That was the scale that Officer Belowski had showed me on scene
And how do you know it's the same one?
because it was packaged by me.
Okay. And so you had an opportunity to look at it. When we look at State's Exhibit 9, what do we actually see inside here?
Inside the box?
What do we see inside the bag? Inside the plastic bag? Is there just a box?
Yes.
Can you see the scale from here?
No.
But you actually, on that date, observed the scale.
Yes.
Okay, I'm going to show you what's previously been marked as State's Exhibit 10B. Also, I'm going to ask you if you recognize what Exhibit 10B is.
Yes, 10B is the digital fusion scale that was located underneath the driver's seat of the black Chevy with Lorenzo and Stacy Record inside that had a white powdered residue consistent with cocaine.
And 10C, is that same scale?
Yes.
Okay, different angle.
Different angle, yes.
And then 10A.
10A is the same scale.
Is that the same box that we see here?
Same box, yes.
And do those appear to be in the same or substantially same condition from when you saw them on that date?
Yes.
You noted that in State's Exhibit 10B that you could see that there was what appeared to be cocaine residue in this.
Yes.
Okay, why did you think that?
Suspected that due to the scale, how small it was. In my experience in training, smaller scales are usually used for crack or sales. And then the white powdered residue, again, was consistent with cocaine residue.
And that was found underneath the seat that the defendant was sitting in.
Correct.
And what, if anything, did you later learn about that scale? Did you find out whether or not the defendant was aware of the fact that scale was there?
Yes.
And how did you know that he knew the scale was there?
I spoke with him on the traffic stop.
Okay. And what did he tell you? Who did he tell you that the scale belonged to?
He advised it was his scale.
Okay. And what did he tell you about the scale?
So I spoke with him, he was Mirandized, and he informed me. I advised him that there was white residue found on the scale. He was telling me that the scale wasn't opened, and that the scale was his, that he just purchased it about an hour ago at Grab and Go, and that was the only scale located in the car.
Did you find any packaging at all for that scale?
No,
Any exterior, like saran wrap or any kind of foil or anything like that?
no,
When you were speaking to the defendant, did he tell you that there was some packaging and foil with it?
yes,
But you didn't see that and it wasn't there in the car?
no.
And in your training and experience, in stores selling scales, if they're in the packaging, do they have cocaine residue on them when you buy them?
Not in my experience.
And when you're looking at it, at the scale, it was clear to you that it had been used?
Yes.
And did you have an opportunity, maybe not that evening, but you, at some point in time, to go to the grab and go and find out if they actually ever sold these scales?
Yes.
And is this a type of scale that is sold at that grab and go?
No.
Do you know whether or not they've ever sold that at that grab and go?
Per the staff, they
Objection.
Sustained.
On that particular evening, when the scale was located, where did you place the scale?
I'm sorry, can you repeat?
Where did you place the scale? Once Officer Gillespie found it, where did you do it?
Once it was found that was evidence, it was collected and secured in the back of a patrol vehicle.
Now, you said that you had an opportunity to speak to the defendant in this matter. What, if anything, did he tell you about whether or not his DNA would be on one of those guns?
When I asked him about the DNA on the firearm, he gave me the response of maybe, maybe not, and then informed me that his DNA would be on the gun because he, in fact, had touched the firearm.
And did he take ownership of anything else in the vehicle?
He did not.
With you mentioned on the seat that there were the firearms and that there was a bag of marijuana. Do you know who that bag of marijuana, did you find out from the defendant who that belonged to?
Lorenzo advised it was his marijuana.
So that was situated by the 10 millimeter magazine and the 10 millimeter firearm and the 9 millimeter firearm.
Yes.
Okay. And you're said that you knew Stacy Riker. Do you know where she lived back on January 31st of this year?
1255 Crescent, that's in Painesville, Ohio.
Okay. And how close is that to where you were for the stop, if you know?
It's on the opposite side of the city, miles.
Okay.
I'd have to look, I don't know off the top of my head.
But she wasn't living in Nebraska at that point in time, was she?
No.
Now, inside the interior of the vehicle, how would you describe like the seats and how things were set up in the inside of that vehicle, that tracks? How many seats were there in the front?
Okay, there was two seats in the, there was a driver's seat and a passenger seat.
Anything in between the seats?
Not that I recall.
Do you know if there was any, sometimes there's like a center console, if you were able to observe that from where you were?
There was a center console, yes.
And was there anything in that center console that you could observe?
Not that I recall, no.
And you said in terms of your training with firearms, with the ejection of a round from the chamber of a firearm, specifically the Springfield firearm, in racking that and ejecting something, which way would that ammunition normally go?
So when you go to eject the round out of the pistol, typically goes off to the right side. So if you're sitting on the driver's side, it would eject towards the passenger side.
Okay. And in order for that round to be ejected in that manner, where would it have to have been within the firearm?
It would have had been in the ejection port inside the firearm itself.
Okay. Not in the magazine?
Not in the magazine, no. It chambers from the magazine.
Hey, just one moment, Your Honor.
Yes.
Thank you, Your Honor. Nothing further at this time.
Thank you. Cross-examination, Mr. Hinton?
Thank you, Your Honor. Good afternoon.
Good afternoon.
You just indicated that you believe that The guns that were recovered, specifically the 10 millimeter, would eject a round out to the right side?
Typically.
Because there are guns that would eject to the left side, right?
I'm sure there are.
And you didn't put a magazine in this gun and perform ejection, right?
I did not.
Now, there's also a chance that this bullet wasn't ejected from a magazine and just happened to make its way onto the floorboard, correct?
Correct.
It could have been pushed out of the magazine.
What do you mean by pushed out of the magazine?
It could have came out of the magazine itself, not the chamber of the gun.
It could have.
Now, on this particular night, January 31st, 2025, you indicated that you observed Mr. Robinson, or Lorenzo as I'll refer him to, in a ski mask when he initially drove by you.
I wasn't able to identify him when he passed me. I didn't know who it was. It was just a person with a ski mask on.
And you later got a better look at this person and was able to identify it as Lorenzo?
During the trap stop, yes.
Okay. And it wasn't a full mask that covered his entire face and had holes for the eyes. It was more so covering the bottom of his face, right?
There was a full cover mask that would cover your mouth and your head and then leave your eyes visible.
Did you happen to take any pictures of that mask?
I didn't.
And you said it was a very cold night?
It was.
And you specifically remember that it was very cold?
I do.
You indicated that when you came over to the passenger side of the vehicle during the stop with Officer McLeod, that it appeared Stacy was sitting on something, right?
Yeah, the way she was positioned.
Okay. But you don't think she was trying to hide anything. She disclosed that there were guns right after you and Officer McLeod came to the vehicle, right?
After she was asked about if there was any firearms or any weapons inside the vehicle, she disclosed that to us.
And these firearms were situated where they were under her, so you couldn't see them initially?
Where I was positioned, I wouldn't have been able to see them.
And she was directly over top of them?
I wouldn't say she was directly over top of them. They're on her left side of her leg, maybe slightly underneath her leg.
Okay. But part of her body was on them?
Yes.
Now, as far as the center console, you indicated you didn't recall anything being in there?
Inside the center console?
Correct.
I don't recall.
What about cups in the cup holders between the two seats?
Are you asking if there's cup holders?
If there were cups or any other objects in the cup holders between the two seats in the vehicle?
I don't recall about cups.
Now, you indicated that a scale with suspected residue was found in the vehicle?
Yes.
And this vehicle was not registered Lorenzo, correct?
It was not.
It was registered Stacy Reichert?
Correct.
And you indicated that Mr. Robinson told you that he had purchased the scale at Grab and Go?
Yes.
Now, did you draft your own report for the actual January 31st, 2025 incident, or was everything in Officer McLeod's report?
The report is in his name, and then I typed a supplement about the follow-up for the scale.
Sure, no. and I'll get to that, but in the initial report, is there any reason why grab and go isn't mentioned?
I don't know.
Are you sure that Mr. Robinson didn't say that he purchased a scale at Falcone's?
He didn't use Falcone's. He had said that he had purchased at the store over there, and I had pointed his head. We were on Richmond Street, which is by Grab and Go, and he had said I purchased a store over there, indicating that it was at Grab and Go.
So he didn't actually say grab and go?
No.
It was more so just kind of pointing in a direction?
Correct.
Now, as far as your trip to Grab and Go, that was August 29, 2025, correct?
Correct.
So that was less than a week ago, right?
Correct.
But this incident that we're here for took place in January of 2025, right?
Correct.
And did you go to Falcone's?
I did not.
Now, you indicated that in your experience, scales generally don't have, anything on them or whatnot. I mean, during your duties, have you had to go into the store and purchase a scale or anything of that nature?
No.
You had indicated that Lorenzo told you that the marijuana was his.
Yes.
At this point in time, marijuana was legal in January of 2025, right?
For the amount he had, it was legal.
Is there any reason why you were asking him about whose marijuana it was?
Just part of the traffic investigation.
Now, as far as your questions to Lorenzo regarding the firearm, you remember talking about that a moment ago?
Yes.
And Lorenzo had told you that when he and Stacy were at a gas station earlier, when Stacy got back inside the vehicle, he moved it and handed it to her. Is that correct?
He realized that the firearm was falling and that he had touched it. Yes.
Okay. Thank you.
Yep.
Redirect examination.
Thank you.
Mr. Hinton just asked you a question about whether or not you put a round in the firearm and check to see how it ejected. Would you do that with a piece of evidence on a case?
I would not know.
Okay. That's for the crime lab to do, right?
That's for the crime lab specialist to conduct.
And when you passed the defendant driving that Chevy Trax, were you able to see any portion of his face?
I was not, no.
And the scale that was found underneath the seat was not in any packaging.
No.
And looking at, just to be clear, with State's Exhibit 10B to residue, was that on the outside of this plastic tongue of the scale, or was it inside on the scale underneath that plastic?
It was inside on the scale.
And was any other scale whatsoever found in that vehicle?
There was not, no.
And the fact that the marijuana was in the vehicle that he took ownership of, along with the scale, were those in proximity to where, close to where the two firearms in the magazine were, as well as the round?
Yes.
Nothing further, thank you, Your Honor.
Recross-examination as to the redirect.
Sir, is there any reason why the marijuana ownership issue isn't addressed in the initial police report?
We're human and we make mistakes and sometimes forget things.
Would you remember it now, several months later?
Yes.
Thank you.
All right, sir, you may step down. Thank you very much.
Thank you guys very much. Thanks, sir.
You're welcome. State may call its next witness.
Your Honor, the state will call Brian Morrison.
Afternoon, please raise your right hand. You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do. Yes.
And whenever you're ready, turn off.
Thank you, Your Honor. Please introduce yourself to the jury and spell your last name for the record.
Brian Morosan, Marosan.
Are you employed?
Yes, I am.
Where are you employed?
I'm employed with the Lake County Crime Laboratory.
And how long have you been employed there?
I've been employed there for approximately 1 year and 10 months.
And what's your position?
I'm a forensic analyst.
Can you please outline your education that qualifies you for that position?
Yes, I have a Bachelor of Science degree in chemistry from Cleveland State University. And following graduation from college, I was employed with the Allegheny County Medical Examiner's Office, which is located in Pittsburgh, Pennsylvania. And I was employed as a scientist where I tested physical evidence for the presence of controlled substances. And in order to complete that job, I completed approximately 6-month training program in the area of drug chemistry. And we covered topics such as evidence handling all the way through how we operate and maintain laboratory instrumentation and equipment. And then when I joined the Lake County Crime Laboratory, I completed approximately 1 additional month of training in order to learn the policies and procedures that are in place at the lab.
And do you have continuing education or training requirements for the Lake County Crime Lab?
We do not have requirements in drug chemistry for continuing education, but we are encouraged to seek out and attend training opportunities as they become available.
And have you testified as an expert witness before?
Yes, I have.
Where?
I have testified as an expert witness at the Allegheny County Common Pleas Court, which is located in Pittsburgh, Pennsylvania, Richland County, Ohio, Cuyahoga County, Ohio, here in Lake County, and in federal court in Northern Ohio.
And approximately how many times?
Approximately 20 times.
Is the Lake County Crime Lab an accredited crime lab in the area of drug chemistry?
Yes, it is.
And what are some of the substances that you test for?
At the Lake County Crime Laboratory, we test for controlled substances, and those can include everything from methamphetamine to cocaine to heroin and fentanyl.
About how many times have you tested cocaine?
Several thousand times.
Did there come a time when the Lake County Crime Lab received evidence from the Painesville Police Department regarding Lorenzo Robinson?
Yes.
May I approach, Your Honor?
You may.
I'm now showing you what's been marked as State's Exhibit 6 and State's Exhibit number 9. Can you tell me what State's Exhibit 6 is?
Yes, State's Exhibit 6 is a copy of our laboratory evidence submission form.
And what of those items would you have tested on there?
I have tested item 3 listed here, is listed as a digital scale with residue.
And what is State's Exhibit number 9?
State's Exhibit number 9 is laboratory item number 3, which is the digital scale with residue.
And does the case number from the submission form and State's Exhibit number 9 match?
Yes, the laboratory case number is 25-000133, is listed here at the top of the evidence submission form, and it is located also on the evidence barcode placed on here at the laboratory, and the numbers do match, as well as the item number.
when you receive that item, what's your first step in testing?
The first step in testing is to ensure that the evidence is sealed properly before analysis.
Okay. What happens next?
Then I will place my initials and date that I open this piece of evidence on the outside of the evidence packaging prior to testing the evidence.
And what happens after that?
And then I will proceed with my analysis.
And regarding that State's Exhibit number 9, how did you test State's Exhibit number 9?
Yes, State's Exhibit 9 contained a digital scale with residue, and at the laboratory, in order to test items that contain residue, I will use a cotton swab, commonly known as a Q-tip, and it will be soaked in a liquid. In this case, it was soaked in methanol. And I will rub that cotton swab over the surface of the object in order to remove any residue that may be present, and that will be absorbed onto that cotton swab. Then I will take the cotton swab and I will dip that swab into a glass vial that contains additional solvent, in this case additional methanol, in order to remove any of the material that may be on that cotton swab so that it's deposited inside that glass vial. And then I will use that glass vial that I have that now contains the residue from the item, and I will analyze that using a piece of laboratory equipment called gas chromatography mass spectrometry, or GCMS for short. And this instrument allows me to identify multiple components that may make up a mixture, and it will allow me to identify what each of those components are in that sample.
And did the process that you just described, did that swab from that scale go through that process?
Yes, it did.
And when you're finished with your test, what do you do?
After I examine all the data that has been generated from the processing of the evidence, I will compile a report with my findings.
May I approach, Your Honor?
May.
Showing defense counsel what's been previously marked as Exhibit 11. Can you please tell me what State's Exhibit 11 appears to be?
Yes, State's Exhibit 11 is a copy of the laboratory report that I've produced in this case.
And what were the results of your testing?
I found that the laboratory's item 3, which was a digital scale with residue, contained cocaine residue.
And is cocaine a scheduled substance?
Yes, it is.
And what is it scheduled?
Cocaine is a Schedule II controlled substance.
And what does it mean for a drug to be scheduled?
The state of Ohio classifies controlled substances into one of 5 schedules, depending on their accepted medical use and their potential for abuse and dependency.
Now, how much cocaine did you find on the scale?
Residue was present on the scale.
And when you say residue, what does that mean?
A residue is a small amount of material that remains on the surface of an object that cannot be removed, and therefore a weight cannot be obtained.
May I have a moment, Your Honor?
May.
Nothing further, Your Honor.
Thank you. Mr. Hinton, cross-examination.
Yes, thank you. Good afternoon.
Good afternoon.
Do you have a copy of your report in front of you that was just referenced to?
Yes, I do.
Are you able to take a look at the first page?
Yes.
Okay. And under results, it indicates that the above item was found to contain cocaine residue, correct?
Correct.
And there's a clarification as to residue, right?
Yes.
And in this particular situation, the amount that was tested by yourself, it wasn't able to be weighed, right?
Yes, that's correct.
I have no further questions for you. Thank you.
Redirect as to the cross.
Now, in preparation for this trial, you came to the office, the prosecutor's office, is that correct?
Yes.
And we actually took the scale out of the box.
Yes, we did.
And we-
Objection.
Yeah, approach. Objection sustained.
When you tested the scale, did you see residue on top of the scale?
Objection.
Overruled.
Yes, I could.
No further questions, Your Honor.
Any reprocess to that question?
No, Your Honor.
All right, sir, thank you very much. Nice to come. State may call its next witness.
Thank you, Your Honor. State will call Officer Taylor Prugel to the stand.
Good afternoon. Please raise your right hand. You swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth.
I do.
All right, good to see you.
Thank you. Thank you.
Whenever you're ready, Ms. Linden.
Thank you, Your Honor. If you could please introduce yourself to the jury and spell your first and last name.
My name's Officer Taylor Prugel. Last name is Prugel.
How do you spell your first name?
Taylor.
Where are you employed?
Painesville City Police Department.
How long have you been with Painesville?
With Painesville, 6 years.
Any other prior law enforcement experience?
I have 10 years total.
Okay, where else have you worked?
I started out Madison Township Police and then went to Willoughby Hills before going to Painesville.
And you're a certified peace officer in the state of Ohio?
I am.
Okay, how long have you been certified?
10 years.
And what kind of training do you have?
OPATA,
Which is what?
basic certificate to become a police officer.
Have you had any additional training at all throughout the time as a police officer in firearms or narcotics?
Many, yes.
And how often?
Multiple times a year.
Back on January 31st of 2025, were you working with Painesville as a police officer?
I was.
Okay, were you a certified peace officer in the state of Ohio?
Yes.
And you have been certified?
Yes.
And do you recall what you were doing that evening, what shift and hours you would have been on?
I was working a platoon night shift. That's from 7 p.m. to 7 a.m.
During the course of your work on that evening, did you come in contact with Stacy Reichert?
I did.
Okay, and did you become involved in a call involving the defendant, Lorenzo Robinson?
Yes.
Okay, and how is it that you became involved?
I was asked to go there to assist on a traffic stop that Officer McLeod had conducted.
And while you're there on the traffic stop, what, if anything, did you do?
I wound up having Stacy sit in my vehicle. It was very cold out that day. So she was sitting in the back of the vehicle, and then I assisted Officer McLeod by writing out the traffic citation and the ALS form.
And how would you describe her demeanor while she was in the car with you?
She seemed upset. She seemed tired. She had her hand on her head the whole time, just very upset.
And while you had her in the car, how long was she there?
I want to say almost half hour. She was inside the car between me writing the citation, the BNB 2255 form, which is the basic ALS, and then also driving her home to her address.
Where did you drive her home to?
To her address at 1255 Crescent in Painesville.
Not in Nebraska Street?
No.
It was in Painesville?
Yes.
May I just have a moment, Your Honor? Nothing further, thank you, Your Honor.
Examination. Mr. Hinton.
Thank you, Your Honor. Good afternoon.
Hello.
During this incident, which you were assisting Officer McLeod on the traffic stop, you did weigh in as to whether or not you thought Stacy was able to legally have firearms, correct?
I was mostly there just to assist Officer McLeod. I didn't run the CCH or anything like that.
Didn't you mention something regarding a gun being stolen previously?
Yes, I have had prior run-ins with Stacy.
And as far as you knew that night, you were of the opinion that she was permitted to have firearms,
Yes,
correct?
yes.
And wasn't there a point in time that night in which the 9mm clip kind of went missing, nobody knew where it was at?
No.
Where Officer McLeod was seeking its whereabouts, and you mentioned to him that you had given it to him?
Yeah, I had found she had given me the magazine I had given to Officer McLeod.
And he indicated that Stacy seemed very tired that night.
Not tired, almost like she was over the situation, just talking to her based off of the things she was saying.
It seemed like she had a headache.
No, I think she was just, like I said, upset about the situation.
Okay. As she sat in your vehicle, there was conversation about all kinds of different things, not just this incident, right?
Yes,
Fair to say. And then you gave her a ride home?
I did.
Okay. Thank you.
You're welcome.
Redirect examination.
Nothing further, thank you, Your Honor.
Officer, you may step down. Thank you.
All right, thank you.
State may call its next witness.
Thank you, Your Honor. The state would call Officer Chad Belowski to the stand. Yes, please.
Good afternoon. Excuse me, raise your right hand. You swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Let's see. Whenever you're ready, Ms. Lynn.
Thank you, Your Honor. If you could please introduce yourself to the jury and spell your last name for us.
I'm Officer Chad Belowski. Last name's B as in boy, A-L-A-U-S-K-Y.
Where are you employed?
I'm employed with the City of Painesville Police Department.
In what capacity?
I am a police officer there.
How long have you been there?
I've been in Painesville for 5.5 years.
Any other prior law enforcement experience?
Yes, I worked in North Perry and Timberlake for about 2.5 years before here.
Are you a certified police officer in the state of Ohio?
Yes.
Have you had any specialized training regarding any kind of drugs, drug paraphernalia, anything like that?
Yes, through the police academy.
And through the course of your work with the Painesville Police Department, approximately how many times have you come in contact with drugs and drug paraphernalia?
At least 50 times.
Now, taking you back to January 31st of this year, do you recall being involved in a stop with Officer McLeod and the defendant Lorenzo Robinson?
Yes, I do.
What was your involvement?
I arrived on scene and I assisted with the inventory of the vehicle.
And when you say the inventory of the vehicle, what does that mean?
That means going through the entire vehicle and documenting any items of value that are inside.
When you're doing an inventory of the vehicle, if you find something that is someone's not permitted to have, what do you do with it?
We collect it as evidence and charge the proper people with that.
And on this particular evening, was there anything while you were doing the inventory that you located that needed to be taken back to the station?
Yes, we found a black digital scale underneath the driver's seat.
And who had been situated in the driver's seat?
The defendant, Lorenzo Robinson.
And when you say you found that under the driver's seat, can you explain what you did, how you were able to find it?
I looked underneath the driver's seat and it dips down a little bit as if it's kind of like a tray. I saw a black box sitting underneath there. I opened up the box and saw a digital scale inside.
And what did you observe about that digital scale?
I saw a white powder substance on the metal tray of the scale.
And in your training experience, what was that? What said that it appeared to be?
It appeared to be some type of illegal narcotic.
And when you were looking through the car, could you tell if you were sitting in the driver's seat of the car, would you be able to reach that scale from where you were sitting?
Yes, you could.
Would you be able to put, from where you're sitting, put a scale underneath where that scale actually was?
Yes, you could.
I'm going to show you what's been previously marked as State's Exhibit 9. I'm going to ask if you can take a look at this, please. Do you recognize what State's Exhibit 9 is?
Yes, I do.
Okay, what is that?
It is the black Fusion digital scale that was found underneath the driver's seat.
I'm going to show you now what's been marked for identification as State's Exhibit 10A, B, and C. Show you first 10A and ask if you recognize what that is.
Yes, I do.
And what is that?
That is the box that the scale was found inside of.
If you're looking at State's Exhibit 9, is that what we see there?
Yes, it is.
And then with B and C, if you look at those, do you recognize those?
Yes, I do.
Okay, and what are those?
Those are the scale that was inside of the box.
And is that what you're referring to, that you saw the residue inside?
Yes, it is.
And when you found this scale underneath the seat, was it in any kind of packaging?
It was not.
Was there any foil, or was there any kind of plastic wrap or anything like that?
No, there was not. Just the box and then the scale inside.
Nothing further, thank you, Your Honor.
Cross-examination.
Thank you, Your Honor. Good afternoon.
Good afternoon.
You indicated that you believe that the scale could have been accessed by an individual in the front seat. Is that correct?
In the driver's seat, yes.
In the underneath the driver's seat could also be accessed by an occupant sitting in the back seat behind the driver's seat, right?
Possibly.
And when you were using your flashlight to look for this, or to search a vehicle, were you in the front or the back seat?
I was in the front.
And other than the scale, was there anything else under that front seat?
There was not.
Thank you.
Redirect examination.
Nothing, thank you, Your Honor.
All right, officer, thank you very much. State may call its next witness.
Your Honor, the state would call Dr. Karen Zavarella.
I did not see the doctor up there, Your Honor.
Let me check. Yeah, we told her to hear it too, Your Honor. Let me check real quickly. I'll give her a quick call. All right, thanks. She'll be here in about-
Approach, please. Raise your hand. You swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Perfect.
Name clear.
Thank you, Your Honor. Please introduce yourself to the jury and spell your last name.
Good afternoon. I am Dr. Karen Zavarella, Z like zebra, A, V like victory, A, R-E-L-L-A.
Are you employed?
Yes,
Where are you employed?
I'm employed at the Lake County Crime Laboratory.
In what capacity?
I am the DNA supervisor.
And how long have you been with the Lake County Crime Lab?
I have been there since October of 2012. almost 13 years.
Can you tell us a little bit about your education and experience?
Yes, I have a PhD in molecular biology from the State University of New York at Buffalo. I was employed at the Cleveland Police Forensic Laboratory as a scientific examiner, where my primary duties were to examine evidence for the presence of genetic material and do DNA testing. I also have experience from that laboratory in drug chemistry and crime scene. I moved on to the Lake County Crime Laboratory again in 2012, where my primary role was a forensic analyst and now as a DNA supervisor.
And do you do any continuing education?
Yes, we are required annually to attend either a conference or do a workshop within our field of expertise, which is forensic DNA, and I continue to do that every year, as well as keep up to date on current events through journal reading articles, as well as establishing associations with other laboratories and discussions.
Are you a member of any professional associations?
Yes, I am a member of the American Academy of Forensic Sciences, the American Society of Crime Laboratory Directors, the Ohio Investigation Officers Association, as well as the International Association for Identification.
Have you previously testified as an expert?
Yes, over 50 times.
And where about?
Lake County Court of Common Pleas, the Lake County Juvenile Court, Cuyahoga County Court of Common Pleas, Cuyahoga County Juvenile Court, and U.S. District Court in Ohio.
Now you said that you were the DNA supervisor, correct?
Yes, that's correct.
And what is DNA?
So let's a little bit of science here just to give you an introduction of DNA and why it might be important. DNA stands for deoxyribonucleic acid. It is a molecule that is found in just about every cell of our body. Whether it's some of the common cellular material you might be familiar with would be blood, saliva, the skin cells, it's in our bones, it's in our hair. And the DNA found in one cell, like our blood, will be the exact same DNA that I would find in any other cell in my body. So it's ubiquitous throughout the body. The reason why it's unique, it's our genetic blueprint. It dictates everything we do, we think, we grow, the way we look. That comes from our DNA. That genetic material is, you can look around the courtroom, and I don't think you see any two people that look alike in here, right? And that's because, with the exception of identical twins, we each have a very unique genetic profile. And it's that uniqueness in our genetic profile that makes it very useful for forensics. So we are able to use genetic material left behind at a crime scene and either exclude an individual as a contributor to that evidence, include with a statistic and an association statistic, or sometimes it's an inconclusive result, but that's what makes it a powerful tool in the field of forensics.
And how do you test for DNA?
So DNA testing is actually a multi-step process. Typically it starts with examining evidence for the source of biological material, and that source could be anything from blood, something like that's very visible, semen, saliva, those are very rich sources of DNA, to what probably is our most commonly requested evidence source of DNA, which is skin cells, something that we can't even see that might be left behind on an evidence item left at a crime scene. So the first thing is I have to collect that. And typically what I do, or what is done, is it is collected off an object. The DNA material is collected using something very simple. If I may even give you an example, we collect that genetic material using a sterile, single-sided Q-tip moistened with some water. So let's say I have this pen right here, and I was given this to collect genetic material from that. It would be probably skin cells. I'm going to make an assumption. I can't see it. But let's say this was utilized in the perpetration of a crime. So I would take this swab, and I would swab the exterior of this pen, and I'm going to hopefully have the genetic material on this swab. So that's the very first step. Next, my role is to see, hey, do we have any genetic material, human genetic material on this swab? So that would be done through a very simple chemical extraction process. And in order to determine whether or not I have genetic material recovered from this swab, I would do something called a quantification step. It tells me whether or not I have human genetic material and whether or not I have enough of that genetic material to proceed forward with genetic testing. And that's like the last lump sum part is if I have enough, we proceed with the genetic testing, which would result hopefully in an interpretable profile.
Now, if you don't have DNA on something, does that mean that it hasn't been touched?
No, that doesn't mean that. There could be a lack of genetic material on an object could result from contamination, such as something that degrades the DNA that was already present there. It could result from not enough genetic material was left behind on that object or collected off that object to develop a profile. There are a lot of different scenarios that can affect a recovery of genetic material from objects.
And what is a contributor?
A contributor. So if we're talking about a contributor to a genetic profile, so we're assuming I have a genetic profile, so let's say I had enough DNA, I developed a genetic profile, and now what I do is I look at this genetic profile and see if I can make it, if it's possible for me to make an interpretation. And an interpretation would be a comparison to a known individual. And a contributor would be anybody that would be the possible donators of the genetic material to my genetic profile. So it could be anywhere from a single contributor all the way up to an endless number of contributors, depending on what the profile looks like.
Now, would you expect to see different results if a person directly handled a firearm as opposed to inadvertently touched a firearm?
So let's talk. I'm going to touch a little bit on what you're gathering. You're talking about contact DNA and genetic profiles developed from contact DNA. So I would like to go over some of the influencers of what can influence genetic material being recovered from an object. So I kind of touched on that just now with saying things that would cause genetic material not to be found on something. I said contaminant that would break it down. So I'm going to go through some environmental things that could cause genetic material to either degrade or disappear off an item. It would be sunlight. UV light is very bad for genetic material. It will degrade DNA, break it down so that we don't get good recovery. Dirt, mold, moisture, also not really great for DNA. It degrades it. It breaks it up, and so that we don't develop a good genetic profile quite often. Other influences of recovery or of DNA being left behind on an object. So we'll talk about duration of how long an individual handles an object. So the longer an individual might handle an object, potentially increases the probability of their genetic material being left behind on that object. The shorter the handling of something, the less opportunity for cellular material to be left behind. We'll talk about the physical attributes of the objects I'm swabbing. Are they rough or are they smooth? A rough object will create friction between the skin and the object, and potentially increasing the potential of DNA genetic material left behind. So a rough surface, but a smooth surface, such as paper, I'm not creating a lot of friction. Well, I might have a few skin cells left behind, let's say on this piece of paper. I probably won't be needing enough to recover, not a lot to recover from that item. But yet there's another attribute that could possibly influence this, and this comes from actually the individual. So some people are known as shedders and some people are non-shedders. Shedders are people that readily slough off their genetic material onto things. Non-shedders, it's the opposite. They tend to retain their DNA. They might have more oily, moist skin that their skin cells stay put a little bit better. So that would be on an individual basis. That would influence it. The longer, typically, one would assume if I'm going to make an inference on whether or not I recover enough genetic material to develop a profile, more prolonged contact is going to be much better opportunity to recover genetic material than just a transient handling of an object.
So is it fair to say that it's more likely the longer somebody holds something, the higher chance of their DNA being on an item?
I would expect.
Hang on. Sustain, rephrase your question, please.
I'll move on, Your Honor. May I approach?
Sure. Good.
Dr. Zavarelli, can you tell me what that is?
Well, what did you hand her? Is it marked?
The State's Exhibit 6.
So I've been handed State's Exhibit 6. This is it looks like a copy. It is a copy of the evidence submission form for laboratory case number 25-000133. And it contains information of items submitted for this that specific case.
I'm now handing you State's Exhibit 1 and 2. And also inside of those are State's Exhibit 1A and State's Exhibit 2A. Can you tell me what these are?
Okay, State's Exhibit 1A is a box, and I can recognize this exhibit through, there's a barcode that was issued by our laboratory upon submission of this item to the laboratory. It is item 001 from case number 25-000133. It is a box containing a firearm.
Is that the same case number that's on the evidence submission sheet?
Yes, that is commensurate with what is listed on the evidence submission form as under item 001, pistol. Okay, same with, let's see, evidence item 2, which is State's Exhibit 2. Also, it's item 002 from laboratory case number 25-000133. And also contains a pistol, which is in line with the evidence submission form under 002, which states a pistol.
Were those items tested for DNA?
Yes.
And where about on those firearms do you typically swab for DNA?
All right. So on these firearms, I've swabbed in very specific areas. I swabbed the textured handle, the grip, or the textured grip of the firearm. And is it loose in there so I can take it out? So I can demonstrate exactly where I swabbed. I can probably hold it up and demonstrate. So here we have the pistol, and this is the grip. I don't know if you can see that the grip is textured or not, but it's got textured areas. So I swabbed this portion of the grip up front, the rear portion of the grip in the back, and on a little bit on the textured sides of the grip. This part here is the slide. I swabbed the textured part of the slide on both sides of the firearm, as well as the trigger of the firearm. In addition, in this case, it was also submitted with a magazine. On the same swab, I did the base, the base, just the edge of the base of the magazine. I did that for items, both for item 1, and then as well as for item 2. Same setup of how I swabbed it. The texture is a little bit different on this grip, but it's the same theory. The back and front of the grip was swabbed. The trigger, right there, as well as the back, this portion of the slide, textured slide on both sides, and in this case also the base of the magazine that was submitted with that.
After you tested or swabbed those items, did you test them?
Yes, I did.
And did you write a report?
I did.
Question to approach, Your Honor.
Nay.
Now showing opposing counsel was been marked as State's Exhibit 12. Dr. Zabarella, can you tell me what that is?
State's Exhibit 12 is an accurate copy of the report I issued in this case, which is laboratory case number 25-000133. And it is report 0003, request 0003.
Is it a fair and accurate copy of your report?
Yes.
Now, in regards to the 10 millimeter firearm that was tested, can you tell me what the results were of that?
So that would be evidence item 1. The swab is sub-itemized as evidence item 001-A. So the DNA profile obtained from the swab of the Springfield Armory XDM Elite Pistol and Magazine. And the XDM Elite Pistol and Magazine is also the 10 millimeter caliber firearm. It was a mixture representing a minimum of 3 contributors. I made a comparison with the DNA standard, which is a cheek swab standard that I developed a genetic profile from, a Lorenzo Robinson. And this DNA mixture profile is 6.7 billion times more likely to occur if the mixture consists of DNA from Lorenzo Robinson and 2 unidentified contributors than if it derives from 3 unknown contributors.
Is that consistent with direct, prolonged contact?
Objection.
Sustained.
What are some things that would make that number be so high, the 6.7 billion?
So let's talk about the statistic. In the field of forensics, a statistic, a likelihood ratio, which is what this is of a million times more likely is considered a very strong association. And so anything above that, and in this case it's 6.7 billion, which is more than a million times more, is even a stronger association. This statistic is the likelihood ratio is simply a look at 2 different hypotheses, one or 2 different scenarios, and they're independent of each other. One scenario would be an individual's DNA. This DNA profile is present if it is the result of the suspect's DNA being on there, or this DNA profile versus this DNA profile is a result of an unknown individual, not the suspect. And a likelihood ratio in favor of the first hypothesis, in this case, came out to be 6.7 billion times more likely than the alternative hypothesis, where it's 3 unknown individuals on there, not inclusive of the suspect.
Now let's talk about the other firearm. Can you tell me the results of that testing?
So the DNA profile obtained from the Springfield Armory XD Model 3 pistol and magazine. That's item 002-A, the swab I collected from the second pistol, is a complex mixture representing a minimum of 5 contributors. And once we get get that high in the number of contributors, that exceeds our laboratory's policy for any kind of interpretation. So meaning I don't make any comparisons because it is such a complex mixture that it's very hard to deconvolute. And making a comparison at that level of complexity, we run the risk of false inclusions or misinterpretations. So we do not interpret genetic profiles of 5 contributors.
So would it be fair to say that you cannot exclude the defendant from that firearm?
No comparisons were made, so I cannot exclude, nor can I include. No comparisons were made.
So does the length of time or duration of handling a firearm increase the likelihood that DNA is on an object?
Again, it would go back to my discussion on things that influence transfer of DNA or getting DNA off an object. can be if there's prolonged contact, direct contact, if we're saying direct contact or multiple contacts with an item, the more likely a potential of leaving DNA behind, and the more DNA that would be left behind.
One moment, Your Honor. Now, I want to talk to you a little bit about the female DNA that's present on the firearm, or is there female DNA present on the firearm?
So we're going to go back to the interpretable genetic profile from item 1A, the genetic profile with 3 contributors at least. In that genetic profile, I'm able to say that there is at least a female contribution to that genetic profile.
And was her contribution in DNA similar to that of Lorenzo Robinson?
So I can't say whether it was one female or multiple females, but the contributions of at least another individual appears to be about equal to the contributions that match Lorenzo Robinson's genetic material on that gun. So an analysis of the actual genetic profile indicates that there is an equal amount of DNA of somebody, at least one other individual on there, in equal amounts as Mr. Robinson's genetic material that is associated with the profile.
So in your opinion, what does that mean? That there's equal DNA on each, equal DNA from 2 people on there?
Can you give me a more? Are you asking about the manner in which the genetic material might have gotten on there? That would be an activity. So in order to give an opinion about the activity of a genetic profile, I have to make it clear at least on a couple of things. First, I have to have that we are going to agree that, let's say, Mr. Robinson's DNA is on the firearm in that genetic profile. Second, I have to have a specific way in which we're discussing. Are we talking a scenario, so to speak? If you can give me a specific scenario versus an alternate scenario, and I could give you what I would expect in a genetic profile versus what I would not expect.
How about for handling a firearm?
For how long?
Objection.
Overruled. You may answer.
Are we talking? Are you talking about like maybe a transient? For example, okay, I'm going to give an example. I'm going to move this microphone from here to there. Okay, I handled it. I don't know how many seconds that was.
Objection. I don't know that there's a question pending.
Overruled. You may continue.
I swabbed that part that I just handled, and I know that Mr. Bailiff, Mr. Stan, also handled this microphone, so I know at least one other individual handled this microphone. I take a swab. Would I expect to find my genetic profile in this scenario? Not likely. It's not likely that I'll be able to develop enough of my genetic profile to make an association with such a transient handling of it. If I sat here and kind of just grabbed it and held onto it for a little bit, where now I'm kind of rubbing it, I increase my potential. So I would expect to find a genetic profile more likely with that more prolonged kind of rubbing mechanism, rather than just a simple movement of the microphone.
No further questions, Your Honor.
Cross-examination, Mr. Hinckley.
Thank you, Your Honor. Hey, good afternoon.
Hi, good afternoon.
You talked a lot about DNA resulting from somebody's skin cells, correct?
Correct.
Okay. But there's other ways that DNA can be transferred, correct?
So there are multiple ways DNA can get on an object and be deposited on an object, sure.
If I walk up and grab one of the firearms that's marked as an exhibit there and sneeze on it, my DNA is going to likely be on it, correct?
Yes.
Okay. or if I cough, or if I spit on it, correct?
Correct.
So when you're analyzing something for DNA, the fact that somebody's DNA is found doesn't necessarily let you know how that DNA made its way to that object, correct?
Correct. It does not. Presence of DNA on any object does not indicate how, and it also doesn't indicate when. Those are two answers that the actual statistic or an association can't tell you.
Thank you.
Redirect examination?
Nothing from the state, Your Honor.
All right, thank you. State may call its next witness.
State has no further witnesses, Your Honor.
You resting at this point?
Yes, pending admission of exhibits.
All right, ladies and gentlemen, as you have just heard, the state of Ohio is rested. That means they have presented all the testimony they intend on presenting in this case. The next step in this trial is to afford the defendant an opportunity to present evidence if he wishes. He is not required to do that. But before I get to that stage, I need to discuss some legal matters with the lawyers outside the presence of the jury. So you'll take your afternoon break right now while we stay in here and do what we need to do. It's not going to take very long. And then we'll come back and resume. But please remember, even though the state is rested, you're not allowed to talk about the case or their case at all, so please do not do that. Don't let anyone talk about it with you or in your presence, and no investigating or researching anything having to do with this case. So if you want to go to the jury room, if you need to use the restroom and step outside for a minute, you can do that, but then come back into the jury room and we'll get you back in here.
All rise.
You may be seated. All right, as for the state's exhibits, what are you moving for the admission of here?
Your Honor, for State's Exhibit 1, 1A, 1B, 2 and 2A, 3A, B, C, D, and E, 4A, B, C, and D, 5A, 5B, Exhibit 6. I think for 6, 7, and 8, we are moving for admission, but I understand that the lab reports would not go back to the jury. Is that a fair statement?
Yeah, I don't send the reports back, so 7 and 8 won't go back. I don't know from 6, but 7 and 8 aren't going to go back.
And then we also move for the admission of Exhibit 9, 10, A, B, and C. And then for 11 and 12, those are the crime lab reports. We understand they won't go back to the jury, but we'd ask that they be part of it.
And so you move for their admission, I'm going to deny that though. So 11 and 12 are not going back.
Okay, and then Exhibit 15, which was the map, and I believe the 16 and 17 that we had. 16 was that certified copy just for purposes of the record, and then the clip that we played for Stacy Reichert. That's.
Those aren't getting admitted, but they're going to be made part of the record.
Thank you, Your Honor.
What about 13 or 14?
We
No?
did not offer those, Your
Okay.
Honor.
And Mr. Hinton, any objection to any of those exhibits?
Thank you, Your Honor. No grounds to object to the exhibits, but just to be clear, the video clip that was played for Ms. Reichert, the judgment entry of conviction for Mr. Robinson, and the Lake County crime lab reports would not go back to the jury, is my understanding.
Correct. 7, 8, 11, 12 are the reports. Those are not going back. The recording that we listened to, or Ms. Reichert listened to, is not going back, and neither is the certified judgment entry of his prior conviction. The stipulation will go back, but not the judgment entry.
Okay, thank you.
All right, anything else for the state?
No, Your Honor, thank you. And I do apologize for the timing with Ms. Severell. We didn't expect that.
No, but it was still, you said she told her to be here at 2, and it was after 2. So that
Understood,
had
Your
nothing to do with you being faster than you thought you had to be. If it would have been 10 to 2, I would have understood, or 5, but it was after that. Mr. Hinton, for the defense, anything you care to address?
Thank you, Your Honor. We would make a motion for acquittal under Rule 29 at this point in time. Specifically, I would indicate that as to count 1, weapons under disability, I don't feel that the state at this juncture in the proceedings has provided sufficient evidence to demonstrate that Mr. Robinson acquired, had, carried, or used a firearm. I think that the evidence demonstrates that whatever contact he had with a firearm was minuscule and so minimal that it wouldn't amount to those 4 standards: acquire, have, carry, or use. As far as the count of improperly handling a firearm in a motor vehicle, count 2, that would require that a firearm be loaded, and I think that the evidence presented as to whether or not these firearms were loaded was insufficient. And in fact, I think it's quite the opposite. I think the evidence tends to show that these firearms were not loaded. As far as count 3, the possession of cocaine, in that count it indicates that cocaine did not exceed or did not equal or exceed 5 grams. I mean, this amount was so small we don't even know how much it weighed, because it wasn't weighable, and it was residue specifically indicated on the report that it was cocaine residue. As a result of those reasons, Your Honor, I'd ask for an acquittal under Rule 29 to counts 1 and or 2 and or 3.
Thank you. For the state?
Yes, Your Honor. In viewing the light most favorable to the state regarding count 3 of the possession, there was a scale underneath the driver's seat with residue on it. 3 officers testified that the residue on top of the scale was readily apparent. Even though it was a residue amount, it was apparent to all the officers. Regarding the having weapons under disability count, the defendant's DNA was 6.7 billion times more likely to be on the firearm if it was his. There was an eyewitness who stated that he handled the firearm for at least 20 seconds. The defendant himself said, when asked if his DNA would be on the firearm, he said maybe, maybe not. And regarding the improper handling, the officers testified today that if a firearm was in the driver's seat, was being handled, and a round was expelled from the chamber, that it would go to the right, and which is consistent with the firearm being loaded. Thank you.
All right, well, the court at this point must consider and view the evidence in light most favorable to the state of Ohio. And in doing that, the court finds that the state has presented sufficient evidence, again, in viewing in light most favorable to the state, to prove all the elements of each of the 3 offenses. So that motion is overruled at this time. So, Mr. Hinton, what is the defendant's intention at this time in regards to the presentation of evidence?
Your Honor, I do want to admit Exhibits A and B that I used yesterday during Stacy Reichardt's testimony. Was the 2 receipts from the purchases. If I may have a very short recess to speak with...
Any other witnesses besides perhaps the defendant?
There would not be any other.
Then we'll take a break and let you get some privacy to talk. You can go in the back if you want, or
okay.
You can go in our conference room, wherever. Stan will give you room to talk here briefly.
Thank you.
Well, first of all, any objection to A or B?
No, Your Honor.
All right, so defendants A and B will be admitted. We'll take about a 10-minute break here, and I want to get started back at 3 o'clock.
Okay, thank you, Your Honor.
I'm going to if he desires. Again, he's not required to do that. Mr. Hinton, what is the defendant's intention at this time?
Thank you, Your Honor. At this point in time, the defense would move to admit our exhibits, which are A and B that were used yesterday. We would move to admit those, and we would not be presenting any witnesses, Your Honor.
So then you'd rest them?
We would. Thank you.
Any objection to defense A and B?
No, Your Honor.
All right, defendants A and B will be admitted. Can I see counsel at sidebar real briefly?
Yes.
All right, ladies and gentlemen, as you have heard, the defense has rested. That means each side has now presented all the testimony and evidence that each side intends on presenting in this case. There are 2 steps that remain to be completed before you can begin your deliberations. The next step in this trial is that I'm going to provide you with the final instructions of law, and then the parties will make their closing arguments, and then I'll have some concluding instructions for you. So in regards to these instructions, again, as I told you at the beginning, I'm not expecting you to memorize these. You're going to get written copies of these. You'll have at least a half a dozen of them back there with you in writing. So you're not expected to memorize what I'm telling you, but I am required to read them to you at this time before we get to that point. So I'm actually going to put them up on the big screen. You can read along with me if you want. You don't have to. You can sit back and just listen as well. But I'm going to begin that at this time. So let me get that up here. All right, you have heard the evidence. You have heard the evidence. The court and the jury have separate functions. The jury decides the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law, nor to apply your own conception of what you think the law should be. A criminal case begins with the filing of an indictment. The indictment informs the defendant that he's been charged with criminal offenses. The fact that it was filed may not be considered for any other purpose. The plea of not guilty entered by the defendant is a denial of the charges and puts in issue all the essential elements of each offense. Now, the defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offenses charged in the indictment. Reasonable doubt is present when the jurors, after they have carefully considered and compared all the evidence, cannot say they are firmly convinced of the truth of the charge. It is a doubt that's based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs. Evidence is all the testimony received from the witnesses and the exhibits admitted during the trial, any facts that are agreed to by counsel, and any facts the court requires you to accept as true. An agreement or a stipulation of certain facts that are agreed to be true requires no further proof by anyone. In this case, the defendant as well as counsel for both sides have agreed upon a written stipulation, joining exhibit number 1, concerning certain evidence, and the stipulation will be with you during your deliberations. Now, evidence may be direct or circumstantial, or it could be both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which that witness testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence, from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. As an example, if you wake up in the morning and see the ground is covered in snow, that is circumstantial evidence that it snowed earlier. Likewise, if you see human footprints in sand, that is circumstantial evidence that someone had previously walked there. To infer, to make an inference, is to reach a reasonable conclusion of fact which you may, but are not required to make, from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal weight. Now, the evidence does not include the indictment or the opening statements or closing arguments. The opening statements and closing arguments are designed to assist you. They are not evidence. You must not speculate as to why the court sustained an objection to any question or what the answer to such question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. Statements that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you never heard them. If the court sustained any objections concerning any statements made during opening or closing arguments, you must disregard such statements made by any attorney. Exhibits as well as testimony related to them have been introduced. You will determine what weight, if any, the exhibits should receive in light of all the evidence. If there is a copy of an exhibit, you should consider it the same as an original. If there are deletions or redactions, you must not consider those parts. The exhibits are identified by their numbers or letters. The fact that numbers or letters may be missing or omitted shall not be considered by you for any reason. Evidence was presented in this case that the defendant was previously convicted of a felony drug offense. This evidence was admitted for only a limited purpose. Specifically, this evidence was... Hang on one second here. I'm sorry about that. All right, I'm sorry about that. I'll start back at the beginning. Evidence was presented in this case that the defendant was previously convicted of a felony drug offense. This evidence was admitted for only a limited purpose. Specifically, this evidence was received in this case because a prior conviction for a felony offense involving the illegal possession of a drug of abuse is an element of having weapons while under disability as charged in count 1. This evidence regarding the prior conviction was not received, and you may not consider it to prove the character of the defendant to show that he acted in conformity or in accordance with that character. You may only consider this evidence for the purpose of deciding whether it proves that the defendant has previously been convicted of a felony offense involving the illegal possession of a drug of abuse as to count 1. Now, you are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You will apply the test of truthfulness, which you apply in your daily lives. Now, these tests include the appearance of each witness upon the stand, the manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things concerning which that witness testified, accuracy of memory, frankness or lack of it, intelligence, interest, or bias, if any, together with all the facts and circumstances surrounding that testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. It is not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. The fact that the defendant did not testify must not be considered for any purpose. Generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express an opinion because of education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you to arrive at a just verdict. Questions may have been asked in which an expert witness was permitted to assume that certain facts were true and to give an opinion based on such assumption. You must determine whether the assumed facts upon which an expert based an opinion are true. If any assumed fact was not established, you will determine its effect upon the opinion of the expert. As with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of an expert. In determining its weight, you may take into consideration the skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to testimony. You should not decide any issue of fact merely based on the number of witnesses who testify on each side of an issue. Rather, the final test in judging evidence will be the force and weight of the evidence, regardless of the number of witnesses on each side of an issue. The testimony of one witness believed by you is sufficient to prove any fact. You are not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. Now, as for the specific charges, in count 1, the defendant is charged with having weapons while under disability. Before you can find the defendant guilty of this offense, you must find beyond a reasonable doubt that on or about January 31st, 2025, in Painesville Lake County, Ohio, the defendant, Lorenzo Robinson, knowingly acquired, had, carried, or used a firearm, and the defendant has been convicted of a felony offense involving the illegal possession of a drug of abuse. Now, the following words contained in the charge set forth in count 1 are defined as set forth below. Knowingly, a person acts knowingly regardless of his purpose when he is aware that his conduct will probably cause a certain result, or he is aware that his conduct will probably be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Knowingly means that a person is aware of the existence of the facts and that his acts will probably cause a certain result or be of a certain nature. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from the facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that he acquired, had, carried, or used a firearm. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon knowledge. Now, the word had is defined as meaning possessed. Possess means having control over a thing or substance, but possession may not be inferred solely from mere access to the thing or substance through ownership or occupation of the premises upon which the thing or substance is found. A person has possession when he knows that he has the object on or about his person or property, or places it where it is accessible to his use or direction, and he has the ability to direct or control its use. Possession of a thing or substance can be either actual or constructive. Actual possession exists when the circumstances indicate that a person had a thing or substance within his immediate physical control. Constructive possession exists when a person was aware of the presence of a thing or substance and was able to exercise dominion and control over that thing or substance, even though that thing or substance may not have been within his immediate physical control. Both dominion and control, and whether a person was aware of a thing's or substance's presence, may be established through circumstantial evidence. Thus, the state may establish constructive possession by circumstantial evidence alone. Two or more persons may have possession if together they have the ability to control it exclusive of others. Ownership is not necessary. A person may possess or control property belonging to another. Firearm is defined as any deadly weapon capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant. Firearm includes an unloaded firearm and any firearm which is inoperable but which can be readily rendered operable. When deciding whether a firearm is capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant, you may rely on circumstantial evidence, including but not limited to statements and or representations and actions of the individual exercising control over the firearm. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specially adapted for use as a weapon or possessed, carried, or used as a weapon. Previous conviction, the parties have stipulated that the defendant has previously been convicted of a felony offense involving the illegal possession of a drug of abuse. Now, in count 2, the defendant is charged with improperly handling firearms in a motor vehicle. Before you can find the defendant guilty of this offense, you must find beyond a reasonable doubt that on or about January 31st, 2025, in Painesville Lake County, Ohio, the defendant, Lorenzo Robinson, knowingly transported or had a loaded firearm in a motor vehicle in such a manner that the firearm was accessible to the operator or a passenger without leaving the vehicle. Now, the following words contained in the charge set forth in count 2 are defined as set forth below. Knowingly, a person acts knowingly regardless of his purpose when he is aware that his conduct will probably cause a certain result, or he is aware that his conduct will probably be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Knowingly means that a person is aware of the existence of the facts and that his acts will probably cause a certain result or be of a certain nature. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from the facts and circumstances whether there exists at the time in the mind of the defendant an awareness of the probability that he acquired, had, carried, or used a firearm. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon knowledge. Had means possessed, and possess means having control over a thing or substance, but possession may not be inferred solely from mere access to the thing or substance through ownership or occupation of the premises upon which the thing or substance is found. A person has possession when he knows that he has the object on or about his person or property, or places it where it is accessible to his use or direction, has the ability to direct or control its use. Possession of a thing or substance can either be actual or constructive. Actual possession exists when the circumstances indicate a person had a thing or substance within his immediate physical control. Constructive possession exists when a person was aware of the presence of a thing or substance and was able to exercise dominion and control over that thing or substance, even though that thing or substance may not have been within his immediate physical control. Both dominion and control, and whether a person is aware of a thing's or substance's presence, may be established through circumstantial evidence. Thus, the state may establish constructive possession by circumstantial evidence alone. Two or more persons may have possession if together they have the ability to control it, exclusive of others. Ownership is not necessary. A person may possess or control property belonging to another. Firearm, again, means any deadly weapon capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant. Firearm includes an unloaded firearm as well as any firearm which is inoperable, but which can be readily rendered operable. When deciding whether a firearm is capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant, you may rely on circumstantial evidence, including but not limited to the statements and or representations and actions of the individual exercising control over the firearm. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specially adapted for use as a weapon or possessed, carried, or used as a weapon. Loaded means ammunition is in the firearm in question and or a magazine containing ammunition is inserted into the firearm in question, and one of the following applies. There was ammunition in the magazine that was in the vehicle in question and that could have been used with the firearm in question, or any magazine that contained ammunition and that could have been used with the firearm in question was not stored in a compartment within the vehicle in question that could not have been accessed without leaving the vehicle, or was not stored in a container that provided complete and separate enclosure. Motor vehicle means every vehicle propelled or drawn by power other than muscular power or power collected from an overhead electric trolley wires. In count 3, the defendant is charged with possession of cocaine. Before you can find the defendant guilty of this offense, you must find beyond a reasonable doubt that on or about January 31st, 2025 in Lake County, Ohio, the defendant, Lorenzo Robinson, knowingly obtained, possessed, or used cocaine or a compound mixture, preparation, or substance containing cocaine. The following words contained in count 3 are set forth or defined as set forth below. A person acts knowingly regardless of his purpose when he is aware that his conduct will probably cause a certain result, or he is aware that his conduct will probably be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from the facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that he obtained, possessed, or used cocaine or a compound mixture, preparation, or substance containing cocaine. To prove that the defendant acted knowingly, the state of Ohio need not prove that the defendant had knowledge of the underlying nature of the controlled substance. The state of Ohio is not required to prove beyond a reasonable doubt that the defendant had knowledge he was obtaining, possessing, or using cocaine. Rather, the state is only required to prove beyond a reasonable doubt that the defendant knowingly obtained, possessed, or used the controlled substance. Possess means having control over a thing or substance, but possession may not be inferred solely from mere access to the thing or substance through ownership or occupation of the premises upon which a thing or substance is found. A person has possession when he knows that he has the object on or about his person or property, or places it where it is accessible to his use or direction, and he has the ability to direct or control its use. Possession of a thing or substance can be either actual or constructive. Actual possession exists when the circumstances indicate a person had a thing or substance within his immediate physical control. Constructive possession exists when a person was aware of the presence of a thing or substance and was able to exercise dominion and control over that thing or substance, even though that thing or substance may not have been within his immediate physical control. Both dominion and control and whether a person was aware of a thing or substance's presence may be established through circumstantial evidence. Thus, the state may establish constructive possession by circumstantial evidence alone. Two or more persons may have possession if together they have the ability to control it, exclusive of others. Ownership is not necessary. A person may possess or control property belonging to another. Now, as you will note, it is alleged the offenses charged took place on January 31st, 2015. It is not necessary the state prove that the offenses were committed on the exact date as charged in the indictment. It is sufficient to prove that the offenses took place on a date reasonably near the date claimed. It is also alleged the offenses charged took place in Lake County, Ohio. The right of this court to try the defendant depends upon proof that the offenses or any element of the offenses were committed in Lake County, Ohio. You must find beyond a reasonable doubt that the offenses or any element of the offenses were committed in Lake County, Ohio. Now, the charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to other counts. The defendant may be found guilty or not guilty of any one or all of the offenses charged. If you find the state proved beyond a reasonable doubt all the essential elements of one or more of the offenses charged in the separate counts in the indictment, then your verdict must be guilty as to such offense or offenses according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of one or more of the offenses charged in the separate counts in the indictment, then your verdict must be not guilty as to such offense or offenses according to your findings. All right, so that concludes the instructions for now. I'll have some concluding instructions in regards to how you should go about your deliberations and conduct your deliberations and fill out the verdict. But before we do that, we're going to hear from the lawyer. So at this point, the lawyers are going to make what are called closing arguments. Let me remind you again that closing arguments are an opportunity for each side to summarize for you what they believe the evidence in the case has established. The state of Ohio, having the burden of proof, gets the chance to go first. The defendant then gets to make a closing argument. And then the state, because they do have the burden of proof, gets the opportunity to make a rebuttal argument. So for the state of Ohio, Mr. Knopf?
Yes, Your Honor. May I use the projector, Your Honor?
Sure, from your desk there? Oh, right. Okay.
All right, ladies and gentlemen, we are done. Now it's time for closing arguments. You're going to hear from us. You're going to hear from Mr. Hintz one more time. You're going to hear from us again after that. So I'm going to go through each one of the charges with you guys. And before I do that, I want to go into some things that I want you to keep in mind as I'm going through that. So, things to keep in mind. There was a scale underneath the driver's seat where Lorenzo was sitting. And on top of that scale was residue. You heard Officer Witt testify to that. You heard Officer McLeod testify to that. You heard Officer Beluski testify to that. There was residue on top of that scale. The defendant also took ownership of that scale. He said that he purchased it from a store about an hour ago, which, take that for what you will. But I've never been to a store and purchased an item and had cocaine residue on that item. Now, I also want to remind all of us that the passenger of the vehicle who lives with the defendant, she sat on that witness stand and she told you that for 20 seconds, approximately, I know that she changed the timing a little bit, but she said approximately 20 seconds, the defendant handled that firearm. And on top of that, the defendant's DNA was also discovered on that firearm. So I want you to keep that in mind as we go through these elements and through the offense and through the jury instructions. So, you're going to see in the charge of having weapons under disability that one of the elements is to have or had. The instructions that Judge Culotta just gave you is going to tell you, told you that had equals possessed. And possession means possession of a thing or a substance can either be actual or constructive. Actual possession exists when circumstances indicate that a person had a thing or substance within his immediate physical control. Now, what's absent from that definition is timing. It doesn't say that there needs to be possession for 1 second, 5 seconds, 10 seconds, 20 seconds, whatever. There's nothing in there indicating that there's some kind of time requirement. Possession is possession. I'm possessing this pen right now. Now, constructive possession exists when a person is aware of a presence, aware of the presence of a thing or a substance and was able to exercise dominion and control over that thing or substance, even though that thing may not have been within their immediate control. Both of those things can be Both of those can be established through circumstantial evidence alone. Something else I want you to keep in mind is that 2 or more people may have possession together if they have the ability to control something, exclusive of other people. Something else to keep in mind is that ownership is not necessary to show possession. We know that Ms. Rockard, she owned the firearms. We know that. That's not in debate here. We agree to that. That's not what we're saying. We're saying that the defendant possessed the firearms and he was not allowed to do that. So let's talk about charge of having weapons under disability. So in order to show this, the state has to show, and in order to prove this, the state has to show you that on or about the 31st day of January 2025 in Lake County, state of Ohio in Painesville, the defendant being under disability. Well, we know he was under disability. We know that was stipulated too. You guys will have that stipulation back in the jury room with you. So we know that he was convicted of a prior offense of drug abuse offense. That was possession of heroin. But we have to show you that he did knowingly acquire, have, carry, or use a firearm or dangerous ordinance. And that is that 10mm pistol, that's State's Exhibit 1. Now, let's apply the facts to the law. Now, as I stated, we know that the defendant was under disability. He has the prior possession of heroin case from the Lake County Court of Common Pleas. That's stipulated too. What else did we have was the direct eyewitness testimony of Stacy Rykard, the passenger of the vehicle, the woman who he lives with, said that he had the firearm for approximately 20 seconds. That is direct evidence of possession. What else do we have? We also have the defendant's DNA on the firearm. That is circumstantial evidence of the defendant's possession. So we have actual possession with direct evidence. We have circumstantial evidence of actual possession as well. Now, regarding the constructive possession, again, we have eyewitness testimony from Stacy Rykard that the firearm was tucked in between the seat and the cup holders. Also, that the firearm was sticking out. The handle was sticking out in the middle console. If you're in a vehicle and you look down, you can see a handle of a firearm sticking out. Now, if someone's sitting next to a firearm, they have the ability to reach over and grab it. All they have to do is simply reach there, grab it, pick it up, unload it, do whatever they want with it. But regardless, possession is what we're talking about here. Possession is simple. It's a very simple matter. If somebody picks something up and has it in their hand, they possess that item. Now, we have all these words describing it, but it's a very simple concept. And we have Ms. Rykard saying that he possessed it for 20 seconds. Now, regarding the improper handling. Now, there is a lot of these elements are the same for both of these counts, for counts 1 and count 2. The only difference being that there is a loaded element to the improper handling. There has to be, the firearm has to be loaded inside of the vehicle. Now, we heard testimony about where the magazine was. We heard Ms. Rykard said it was behind her right side. We heard the officers testify that it was on the left side. But what's interesting there is that there was a 10 millimeter round on the floor. The 10 millimeter round is the firearm that the defendant possessed, that the defendant's DNA was on, that Ms. Rykard said that he possessed. The 10 millimeter round, I would submit to the court that a round was unchambered from that firearm and handed to the passenger of that vehicle. Now, regarding the possession of cocaine, what we have to show to you is that on or about the 31st day of January 2025 in the city of Painesville, Lake County, state of Ohio, the defendant didn't knowingly obtain, possess, or use cocaine or a compound mixture, preparation, or substance containing cocaine, a Schedule II controlled substance. Now, how do we know that the defendant knowingly possessed cocaine that day? Again, we have scale with apparent cocaine residue underneath the driver's seat. The defendant took ownership of that scale, so he knew it was there. We heard Officer McLeod testify that the cocaine residue was apparent on the scale. We heard Officer Witt testify that the cocaine residue was apparent on the scale. We heard Officer Maluski testify that the cocaine residue was apparent on the scale. We also heard the crime lab, Brian Morrison, testify that when he tested the scale, the cocaine residue was apparent on top of the scale. So what I want to impress upon you is the whole situation. Now, on January 31st, 2025, Officer McLeod was patrolling his area. You heard that he was in A zone. He saw a vehicle drive past. There was a driver who had a ski mask on. He didn't identify the passenger yet, but there's a driver with a ski mask on who raised his suspicion, who slouched down in their seat. Officer McLeod hasn't pulled the car over yet, but he begins following them. He sees a equipment violation and then pulls them over. He walks up to the vehicle. He asks if there's any firearms inside the vehicle. The passenger says yes. There's 2 firearms sitting on top of one another. Why is that? Why is there a round on the floor? Why does the defendant, why is his DNA on that firearm? Why is his DNA 6.7 billion times more likely to be on that firearm than another person? Why does he have a scale with cocaine residue underneath his seat? Now, I want to talk a little bit more about some of the other things that Ms. Reichardt said. When she was speaking with the officers, she said that she handed everything, or that that the defendant handed everything to her. And what was on that seat? Again, 2 firearms, a bag of marijuana, and a clip, a magazine for a firearm. Everything was handed to her. Some of the other things that were on the record that she said, I'm not going to lie, he's threatening me. That's what she told the officers at that stop. But the main thing, ladies and gentlemen of the jury, that I want to press upon you is the possession, once again, of the firearm. She said it. For 20 seconds, he had that firearm. Again, it doesn't matter if it's 1 second, 2 seconds, 3 seconds, 4 seconds, 5, 10, 15, 20. It doesn't matter. He possessed it. He had that firearm. And again, his DNA is also on that firearm. And when we're talking about the cocaine charge, there is no amount that's required. It doesn't have to be over 5 grams. It doesn't have to be less than 5 grams. It doesn't have to be 0.05. If there's cocaine residue that's apparent on your scale, you are in possession of cocaine. So, ladies and gentlemen of the jury, I would ask that you find the defendant guilty in all counts.
Thank you. Mr. Hinton for the defendant.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. Again, myself and Mr. Robinson, thank you for your service. You've now heard the extent of evidence that's being presented to you in this matter. Now, in this situation, I want to reiterate the fact that I believe the state provided inadequate evidence. You heard the phrase 20 seconds repeated several times during the state's closing argument, and if you recall, that was a random number that Ms. Stacy Reichardt, who I'll refer to as Stacy, stated when she was asked how long Lorenzo Robinson, who I'll refer to as Lorenzo, had touched the gun. Her saying 20 seconds was an estimate. Could have been 5, could have been 10, could have been 15, could have been 20. Similar to when Officer McLeod testified that he thought he had spoken with Stacy for 20 minutes, and when I asked him again about it, maybe it was 10, 15, and again, no one to fault here. This was an incident that took place in January. We're now in September. So again, the fact that we're putting so much emphasis on Stacy pulling 20 seconds as a response here is a sign of this inadequate evidence. Another sign of this inadequate evidence is this single bullet. Think about it. And I'm going to hit it in more detail, but a large part of the state's case as it relates to the improperly handling a firearm in a motor vehicle is related to this bullet, because to prove that charge beyond a reasonable doubt, it has to be proven that the gun was loaded, and there's so much emphasis put on this one bullet as to try to persuade yourselves that this gun was loaded. There's a lot of emphasis put on the word consistent, and who is consistent and who's not. I'm going to get into that more. And there's certainly a lot of emphasis put on the word possession. But again, it's inadequate evidence in this situation. Now, if you recall from the testimony, this particular night, as Officer McLeod on a Friday night at 11 o'clock p.m. was patrolling, he didn't receive a call that there was a suspicious vehicle or that there was someone riding around in a ski mask, or that someone was alarmed by this or alerted. He simply was, according to him, kind of peering into windows of vehicles, or that's something that he may do to see if someone that he recognizes, someone that has a warrant or whatever else. He sees an individual, can determine that there's some sort of mask on the person's face, can't tell the difference between Lorenzo, an African-American male, and Stacy Reichard, a Caucasian female, but nonetheless, this is enough for him, along with an alleged slouch, to pay a little more attention to this vehicle. And